All right, the teams are in the breakout room. They're discussing some pretrial matters. We had just a hiccup as far as getting logged on, getting going, but we will be started here shortly. If there's anyone for the live streaming who's watching this, just bear with us. We will be going here just a few minutes behind schedule, but we'll get it moving.
And Your Honor, just a quick timing question. How would you prefer we give the teams their times at the halftime and then before closing? Do you want us to say it out loud, or would you like us to put it in the chat?
Excellent. That's excellent. You know what? I think the more with the timing, the better. So if you want to put it in the chat, that's fine. And feel free to coordinate relating to the time as well to make sure that we're keeping as accurate timekeeping as possible. And I will definitely take a break at halftime and then right before closings. And if there is to be, and we can address this in housekeeping matters as well for the advocates, but I prefer if there's at least a 1 minute warning if somebody's going to run out of time, or the advocate can ask for whatever sort of interruption they would necessarily like. And I'll address that in housekeeping.
Of course.
I just sent a message to the teams to see if they're almost finished with some of their pretrial conference. That way we can get started with things here. I recognize those names as coaches, the witnesses. All right, so we do need and Ms. Baxter. Ms. Baxter, are you able to unmute?
Very good to meet you. So sorry that I could not. My personal Zoom kept overriding the credentials.
It's a trick there to sign out and to make that happen. So if it's okay, I'll just kind of run it since I've got the control here, but great. Well, thank you for being here. We do appreciate it. I do see that we have enough of the scoring jurors And so we'll go ahead and get started just as far as a preliminary aspect, not housekeeping the rest of it. This is just making sure we're running smoothly. Have the parties had enough time to confer?
Yes, sir. We have.
Yes, Your Honor, we have had enough time to confer.
All right. Everybody have everyone here who's supposed to be here in this particular courtroom?
We're good
Yes.
from the plaintiff, Your Honor.
Great.
Defense has
And-
everyone in the room that should be here.
Perfect. And I am doing the live streaming. I believe that is working. There doesn't seem to be an issue, so we have that going as well. If you'll give me just one moment, and then we'll get started with some of these things here as well. So give me just one second. All right, I'm going to ask the scoring jurors if there are any conflicts that you're looking at the names of the advocates that are here, the names within the participant list. Do you see anything that would be a conflict where you feel that you would have to step out of this particular trial?
Not for me, thank you.
All right, Ms. Knapp, thank you. And Ms. Baxter?
Yes, Your Honor.
Any conflicts at all with any of the named people that you see in this listing?
There are no conflicts, Your Honor.
Wonderful. Thank you so much. All right. I believe that we're in good shape that way. So let's go ahead and get started. We are here for the second round of this year's Summit Cup tournament. Will the attorneys please make an entry of appearance?
Your Honor, my name is Jessica Cox, and I'm here on behalf of Cam Donaldson, the plaintiff.
Your Honor, my name is Amanda Wang. I'm here on behalf of Cam Donaldson.
All right. And from the defense?
Yes, Your Honor, my name is Karnik Hajar, and along with my co-counsel Robert Fairbanks, we represent the defendant in today's case, Ms. Karen Baja.
All right. Now, we've already done the conflict check. We have the other parts of this going. We know that the sides are ready to proceed. So what I'd like to do now is have everyone swear in. And if we could have the witnesses appear on camera for this as well. Please raise your right hand. And please indicate by saying, I do, if you swear to abide by the rule of this proceeding and conduct yourself in a manner that is honorable to this forum.
I do.
I do.
I do.
All right. Now calling case number 082263, Cam Donaldson versus Karen Baja. Parties have made their entries. From the plaintiff, are there any housekeeping matters?
Yes, Your Honor, just a few housekeeping matters, and then we have a few substantive matters as well. May we assume that all witnesses have been constructively sworn?
Yes.
And as far as already admitted exhibits, would you like us to ask to publish them every time or just the first time?
I'm kind of a stickler that I like people to ask to publish. I understand, but there is, understand that you don't have to go through such formality with an exhibit that's been entered and we're familiar with that exhibit. You could basically just say, announce to the court, publishing exhibit such and such, and then it'll go from there. We don't have to go through such formality at that point. Does that make sense?
Yes, Your Honor, that does make sense. We also
Great.
have a few substantive motions as well, if you would like to hear them at this time.
Not just yet. I'd like to stick to housekeeping matters and then we'll get into that. From the defense.
Yes, Your Honor, the defense only has a few additional housekeeping matters. First, due to the virtual nature of this trial, may we assume that opposing counsel has any exhibits that we identify throughout the trial already in front of them for the purposes of authenticating, impeaching, cross-examining, etc.?
Yes, it's standard thought that all the witnesses have all of the information before them. I have a copy of all of the case materials in front of me as well. So you don't need to reference, you can just reference the materials and everyone should be on the same page.
Yes, Your Honor. And due to the constraints of a virtual trial, would it be acceptable if the defense remained seated during objections?
You can do whatever you need to do. That's absolutely fine. The format in this particular virtual format is unusual. And so I'm not requesting the formality of standing and the rest of that. Of course, do whatever you're comfortable with and whatever you have prepared.
And with that, Your Honor, the defense is ready to proceed into any substantive motions.
Okay, I'm going to turn it back to the plaintiff, but before I do so, the court has a few housekeeping matters as well that I would like to just make everyone aware of. First and most importantly, timekeeping. The witnesses will be keeping time, the expert witnesses in this particular case, and they will be coordinating with each other, kind of checking time. I have given them free rein to also send a message in chat, basically, to give parties an update on time. But I will be taking a break at halftime and also right before closing in order to get a time check, okay? And if on your particular aspect that if you want to keep time as well, and if you think that there's a very large discrepancy, we can certainly bring that to the court's attention and we can figure that out, okay? Great. Secondly, for the court, for openings and for closings, I would prefer that all advocates, we turn off all of our cameras except for the person who is presenting. So that means that has the full screen, the full stage, so to speak. That's what I would like to see for opening and for closing. Now you can unmute or do whatever you need to do if you need to raise an objection. And then if an objection happens during an opening or closing, feel free to then bring your camera up as that has been called. Does that make sense?
Yes, Your Honor.
Otherwise, through the rest of the trial, we will have the opposing advocate will be on camera and ready to appear. Great. All right, so if there aren't any concerns with that, let's move to the substantive matters, the motions in limine, and I'll hear from the plaintiff first.
First, Your Honor, plaintiff offers Plaintiff Exhibit 1, the bank statements of the decedent Lou Donaldson, into evidence. This is a self-authenticating document under Rule 901.
All right, is there any objection to having that self-authenticating document brought in at this time?
No, Your Honor, the defense has no objection to that document.
Okay, so that the bank records will be Plaintiff's Exhibit 1, okay? And that is already pre-admitted by stipulation.
Second, Your Honor, this court should take judicial notice of its own court record, a temporary restraining order filed by Lou Donaldson here in the District Court of Pioneer County, Statesville, and instruct the jury that this is an official court record. And at this time, plaintiff offers this temporary restraining order as Plaintiff's Exhibit 2.
All right, is there any objection to that?
Yes, Your Honor, we do object to the statements of Lou Donaldson within the temporary restraining order being admitted on the grounds of hearsay. May I be heard?
You may.
Your Honor, the statements within that document are hearsay statements. They're statements of Lou Donaldson. They are statements that were made out of court, and there is reason to doubt their trustworthiness. If I may proffer, the court denied the restraining order because it found them not credible statements. And so for those reasons, we argue that it should be excluded on the basis of hearsay.
All right, are there any other aspects to it besides the hearsay?
Your Honor, we have no other basis for exclusion rather than hearsay.
Okay, great. And counsel, your response to hearsay then?
Yes, Your Honor. Before I respond, would you like to see the document?
I'm familiar with all documents.
Yeah. Your Honor, as far as hearsay, this is an exception to hearsay under Rule 803.8, the public record exception. On the document itself, you can see that this isn't just a filing or a copy of a filing made by Lou Donaldson. It actually has the court stamp on it as well as marked for court use, meaning that this was a document produced from the court, which is corroborated by testimony from Taylor Pride. It sets out a matter that was observed while the court was under legal duty to report a denial of an order filed with this court. And additionally, because this is a copy of a court filing, there's no doubt to the trustworthiness of a document from this court. So this is an exception to the hearsay rule.
Counsel, do you have a response to that?
Yes, Your Honor. While the document might fall under that, there's levels of hearsay here. Our objection is specifically to the statements of Lou Donaldson on that document and the content of those statements. And those do not fall under public records exceptions.
All right. Now we're constructively outside the realm of the jury, and I am familiar with the document. If you could be specific as to that within that temporary restraining order, and I can help. I've got the document in front of me, but I would like specifics if you don't mind.
Your Honor, there are 3 statements that were prepared by Lou Donaldson on that document. The first is Karen Baja, defendant has threatened to kill me. The second is I am seeking a divorce from Karen Baja. And the third is I do not feel safe around Karen Baja. We argue that those three statements are hearsay and should be excluded.
I'm taking a look at the document now based on the hearsay objection within that. I believe that this document would overcome any hearsay objection through that aspect. And based on that particular objection, I'm going to overrule it and I will allow the exhibit to be entered. And that will be Exhibit 2.
Lastly, Your Honor, we intend to offer a testimony of a witness today, Exotic Bob, through the use of video testimony. We ask this court to exclude a portion of that testimony from 30 seconds to 1 minute 08. The portion that we are asking this court to exclude goes into a charge that Exotic Bob is currently awaiting trial on and has not been convicted of yet. Your Honor, we believe that showing the portion of this video would be highly prejudicial, more substantially prejudicial than it would probative, and would additionally mislead the jury, as Exotic Bob's pending criminal charges are not at trial here today.
Counsel, your response.
Yes, Your Honor. Under Rule 106, under the rule of completeness, we ask that if plaintiff wishes to offer any portion of this recorded statement of Exotic Bob, that we do reserve the right to request that any other part be considered by the jury. And so we would only request that the full video be played and that no portion of the video be excluded because plaintiff wishes to offer the video, a portion of the video to evidence. And in fairness, the full video should be available for the jury to consider.
I am familiar with the video, and counsel, I'm not seeing necessarily the same issues with it that you are, Ms. Cox. So I'm going to overrule that objection. The video may come in its entirety.
Your Honor, may we ask, as far as it coming in its entirety, since plaintiff only intends to show a portion of it, may defense use their cross-examination of their own time to show the portions that they wish to show?
Counsel, do you have a response to that request?
Your Honor, the rule of completeness allows us at that time that the video is introduced to request that the full video be played for the jury, because the jury ought to be able to consider the video in its entirety. It's the fairest way for the jury to be able to evaluate that video and evaluate the credibility of the contents of that video. And so to that end, we ask that the full video be played at the time that it is going to be played.
Your Honor, may I briefly respond?
You may.
Rule 106 is a discretionary rule, and as Your Honor stated, since the entire video is going to be played, the reason that we're asking that to go into defendant's cross-examination time is simply due to the time restrictions that we have for this trial. That way, both parties are given a chance to play the video, and as long as it's played in its entirety in defendant's cross-examination time, that would meet the Rule 106 recommendation, which is up to the discretion of this court.
Counsel, that's very well argued, and I do appreciate that. But I don't believe that the video is very long in and of itself. I think it's less than 4 minutes, if that. We're not talking about a lot of time. And if we run into a tough spot with time, I will entertain adding a minute here or there on either side, depending upon this. But if we're going to play the video, I think it makes the best sense for the jury, instead of piecemealing it, to just play the entire video at one time and have that testimony come in.
Yes, Your Honor, and those are all the substantive motions from the plaintiff today, and we are ready to proceed.
All right. Now and sorry, just for a clarification, for the video, was that a limiting, or were you trying to pre-admit necessarily that video?
We were asking, Your Honor, to exclude a portion. We are not pre-admitting the rest of the portions that we wanted to play.
Okay, so based on my ruling, are we still having the entire video as exhibit number 3, or are we not having that as an exhibit yet?
We are not yet offering it as an exhibit.
Okay, that's the clarification I needed. So we've had 2 exhibits that have been entered, exhibit 1 and exhibit 2, that have already been pre-admitted based upon the rulings of the court and the stipulation of the parties. Great. Are there any other motions in limine from the plaintiff?
No, Your Honor, there's no further motions in limiting from the plaintiff.
All right, then from the defense, your motions in limine.
Yes, Your Honor. The defense moves to exclude a letter and any testimony about a letter authored by one Samantha Lane. If I may be heard.
You may.
Your Honor, the defense moves to exclude this piece of evidence on two grounds. First, the lack of authentication, and second, the lack of hearsay. Your Honor, the defense contends that neither party is capable of laying the foundation needed to authenticate the letter that is purportedly from Samantha Lane. Neither the plaintiff's expert nor the defense expert was able to communicate with Samantha Lane after this letter was first given to the defense expert. Neither of them were able to verify that that letter was in fact authored by Samantha Lane, and so neither party will be able to verify and authenticate that letter. And even if it were to overcome those authentication issues, Your Honor, there's still remaining hearsay issues in which this was an out-of-court statement that would be offered for the truth asserted that Samantha Lane did not in fact sign that will of her own free will.
Counsel, your response.
Yes, Your Honor. Under Federal Rules of Evidence 703, an expert witness is allowed to rely on hearsay testimony. So it is allowed that Taylor Pride or Chris Renard relies on what Samantha Lane says. Further, under 804B3, she qualifies as an unavailable witness and is making statements against her own interests. For your information, Your Honor, Samantha Lane is admitting in the letter to forging the will. And so any statements in regard to her actually committing this type of forgery is against her own interest and would overcome the hearsay exception.
Counsel, your response to that.
Yes, Your Honor. First, regarding Ms. Wayne's 703 point, while an expert may rely on hearsay testimony in coming to a conclusion, such facts may only be disclosed to the jury if they are substantially more probative than they are prejudicial. And letter that cannot be authenticated, that we cannot be certain that it comes from the person that it purports to come from, would certainly not meet the bar of being substantially more probative than it is prejudicial. Its prejudicial value would be too high to allow it to meet that bar. Regarding Ms. Lane's unavailability, before we can get into 804B exceptions, we must first establish that Ms. Lane is in fact unavailable under 804A. And I would like to hear any foundation that can be laid that actually concretely shows that Ms. Lane is an unavailable witness under 804A prior to going into any 804B exceptions.
Counsel, do you have a response to that?
Yes, I do, Your Honor. Under 803A5, she's an unavailable witness. She cannot be found. Both Taylor Pride and Chris Renard in the report say they have no idea where she's at. Therefore, she does fall under an 804A exception. It would be 5, an unavailable witness for this trial.
Any last word? And I believe it's Mr. Hajar. Am I pronouncing that correctly?
Yes, Your Honor.
Great.
All I would ask is that if that is Ms. Wayne's contention, then that foundation be laid in trial prior to any ruling being made on the issue of 804A unavailability.
All right. That was the direction I was heading at this point as well. So I'm going to reserve ruling. I know that's somewhat of a punt at this point, but that's what I'd like to do. I'd like to see if the foundation can come in for this. At this point in time, I don't know if we'll be able to authenticate that particular document. I understand, but it depends on the foundation that you're able to get out through the experts or whatever witness that you're going to try to do this in order to get us there. I'm leaning against admission at this point, but I'm going to wait and see how things play out in trial, and we can re-raise those objections to that particular document in a timely fashion. Mr. Hajar, if you'd like to do so, okay? Or your co-counsel, either one. All right, so I'm reserving ruling on the letter. Any other motions from the defense?
Your Honor, the defense has no other motions in limine and is ready to proceed into opening statements.
All right. If the parties are ready, that was the motions in limine section for the timekeepers. This is where the actual 70 minutes begins to start, and the timekeepers will continue to coordinate for that. And with that, if the parties are ready, let's go ahead and proceed to opening statements. And if the parties will, except for the advocate, will take their camera off.
May it please the court. It wasn't a coincidence. It was now or never. Members of the jury, my name is Jessica Cox, and I'm here today with my co-counsel, Amanda Wayne, on behalf of Cam Donaldson. Cam Donaldson is suing the defendants for the wrongful death of Lou Donaldson, her father and the owner of a big cat tiger sanctuary who disappeared on August 17th, 2012, and was never seen again. Everyone here today is going to agree that we don't know where Lou Donaldson's body is. And we don't know if we will ever be able to tell you. But while the defendants will want you to believe that Lou Donaldson's death was some kind of chance coincidence, what you're really going to learn today is that his disappearance wasn't a coincidence at all. It was a get-rich-con. It was the summer of 2012, and the defendant knew that her time was running out. She knew that her time was running out because on June 12th, 2012, she found out that her husband had filed a restraining order against her. You're going to get to see that restraining order today. And it was filed by Lou Donaldson because he no longer felt safe in his own home after the defendants had threatened to kill him. And then over a month later, the defendant found out that not only did her husband, Lou Donaldson, want a legal protection barrier against her, he wanted a divorce. And finding that out led to a very angry confrontation by the defendant. And then on August 17th, 2012, it was a Friday after work that Lou Donaldson was leaving that day. He stopped at his daughter Cam Donaldson's desk, and he told her that he'd see her on Sunday for dinner. But Lou Donaldson never showed up. Because after that day, no one saw Lou Donaldson again. But the defendant wasn't done yet. Because for the defendant, you'll find out that it was now or never. 36 hours after the last time that anyone saw Lou Donaldson alive, the defendant went to the tiger sanctuary in the early hours of the morning and took a lockbox that contained Lou Donaldson's will. And then 5 years passed. And that's when you're going to find out that the defendants finally got what she wanted. You see, the law here in Statesville tells us that you can't have someone declared legally dead until at least 5 years has passed, which means that no one is getting a dime until that time period is up. And for most spouses, that's not a problem because they're not in a hurry to have their missing husband declared legally dead. But 5 years to the day, the defendant had her paperwork ready. She marched up to the courthouse and she had her husband, Lou Donaldson, declared legally dead. And that same day, she called up the insurance company and cashed out Lou Donaldson's $5 million insurance. But she wasn't done. She then came up with a will that you'll hear no one has ever seen of or heard of before. A will that gave her everything that Lou Donaldson owned. And you're also going to get to see this will today. And I want you to pay special attention to the date that that document was signed by Lou Donaldson. Because it was signed just 2 days after Lou Donaldson filed for a restraining order against the defendant. Just 2 days between when he never wanted to see her again. 2 days between when he wanted the law to keep her away and when he wanted to give the same person that threatened to kill him everything that he owned. That's what the defendant will want you to believe today. And members of the jury, that's why we're here today. We brought this suit on behalf of Cam Donaldson to recover for the wrongful loss of her father, Lou Donaldson, and the loss of his dream, the Tiger Sanctuary. At the end of this trial, the judge is going to come before you and ask you to determine whether or not the defendant, Karen Basha, wrongfully killed Lou Donaldson. And we do have the burden today to prove this to you, a burden of preponderance of the evidence, more likely than not. And from the evidence that you're going to see here today, the answer is clearly yes. You're going to first hear from Taylor Pride. Taylor Pride is a detective and a handwriting expert who's going to tell you about the investigation that he did into Lou Donaldson's disappearance. Taylor Pride also took a look at Lou Donaldson's will, and you're going to hear that the signature on that will is not the signature of Lou Donaldson. You're also going to hear from both experts on both sides of the case today that in their 45 years of combined experience, neither one of them has seen the language, "should I die or disappear," used in a will before. But that's what you're going to see in the will that the defendant came up with that gave her everything that belonged to Lou Donaldson. We expect that Detective Pride will tell you that after his investigation, by looking at the circumstances, the forged will, the death threats, the impending divorce, that Karen Basha is responsible for the wrongful death of Lou Donaldson. You're also going to hear from Cam Donaldson today. Cam Donaldson is going to tell you about her father, about the relationship that they had, and she's also going to tell you about how her dad loved to fly. Now, we expect that the theory you're going to hear from the defense today is that Lou Donaldson just got in one of his planes and flew off to start a new life in Costa Rica. And they're going to want you to believe that, even though Cam Donaldson will tell you that Lou Donaldson needed eyeglasses to be able to fly. And those glasses were found a week after he disappeared. Not to mention that you're going to hear that a detective team was sent to Costa Rica and there was no sign that Lou Donaldson was or had ever been there. By the end of this trial, you're going to see that Lou Donaldson's death, it wasn't a mere coincidence. It was now or never for the defendant to sink her claws into Lou Donaldson's fortune. And members of the jury, she's going to try and con you today too, to convince you that she had nothing to do with Lou Donaldson's disappearance. We look forward to presenting our case to you today.
From the defense, opening statement.
Yes, Your Honor. Off the books, off the grid, and off the hook. Members of the jury, Ms. Cox just came up here and she told you a story about how this is not just a coincidence, that Karen Basha was just waiting to sink her teeth into her husband's money. But my name is Karna Kajar, and along with my co-counsel Robert Fairbanks, we represent Ms. Basha. When you hear the evidence unfold today, you'll realize that this isn't a story of a tigress of a woman. Members of the jury, you'll hear the evidence today, and it'll show you that this is a story about her husband, Lou Donaldson, a man who liked to live his life off the books until he went off the grid and ultimately wanted to make sure that he was off the hook. I'm going to start by telling you a little bit about what you'll hear about Lou Donaldson's relationship with Karen Basha. Members of the jury, when she takes the stand, she'll tell you they met when she was hitchhiking. She'll tell you he rode in like a knight in shining armor, her Prince Charming, there to save the day. She'll tell you the minute that she met him, she knew he was her soulmate. But members of the jury, you'll hear today that this wasn't only the start of a romantic relationship, it was the start of a business partnership too. See, when Ms. Baja takes the stand today, she's going to tell you a lot about Wild Wild Life, the big cat sanctuary that she worked in along with her husband. She'll tell you it was a place where leopards, lions, and tigers made their homes, a place where they ate, slept, and even gave birth under her watchful eye. Now, all of this isn't to say that everything in their marriage was rosy. You see, members of the jury, Ms. Baja will tell you that from the very beginning, Lou Donaldson's family, and particularly Lou Donaldson's daughter Cam, weren't big fans of her. She'll tell you that from the beginning, they thought that she was greedy. You'll also hear a lot about Lou Donaldson, because Ms. Baja is going to tell you he was a secretive man that liked to live his life off the books. You see, what you'll hear today, members of the jury, is that while Lou Donaldson may have been the owner of Wild Wild Life, he wasn't exactly the operator of it. You'll hear that Cam Donaldson ran a lot of the day-to-day business. You'll hear that Ms. Baja took care of the cats. You'll also hear that Lou Donaldson liked to fly planes. He flew planes with unregistered flight plans. He never chartered a flight log. Members of the jury, you'll hear that he flew on a suspended pilot's license. And it's all of that that brings us to when Lou Donaldson chose to go off the grid. Because members of the jury, when you hear about the year 2012, what Ms. Baja is going to tell you, she's going to tell you it was a particularly difficult year for their marriage. It was difficult because Ms. Baja found out that Lou Donaldson had a mistress. She'll tell you that when she found out that he had a mistress, she was upset. But she thought that they could work through their marriage. She was ready to make it work. Ms. Cox got up here and told you about the night of August 17th, 2012. But Ms. Baja, when she takes the stand, she will tell you exactly what she was doing the night of August 17th, 2012. She'll tell you that that was the night that she was working particularly late at Wild Wild Life. She was taking care of tiger cubs that had been abandoned by their mother. She'll tell you that in the early hours of August 18th, 2012, she realized she needed more supplies to care for these cubs. So, members of the jury, she got into her car and she drove. She drove to the supermarket to buy those supplies. Then on her way back to Wild Wild Life, her car broke down. Ms. Baja will get up on that stand and she'll tell you that at that moment, she called her brother. Her brother, who was a sheriff, who was patrolling the area where her car broke down that night. And then she'll tell you about how on all of August 18th, she waited to hear something from her husband that she hadn't seen. Ms. Baja will tell you for all of August 18th, she didn't hear anything. She'll tell you for all of August 19th, she didn't hear anything. In fact, Ms. Baja is going to tell you that for the full week, Lou Donaldson was nowhere to be found. And at the end of that week, she got back into the car with her brother. She drove to a hangar 40 miles away. She found her husband's van, a van that had his glasses and his keys. Members of the jury, Ms. Baja will tell you that she realized that Lou Donaldson had gone off the grid. But Ms. Baja held hope, so she waited. She waited 5 long years, hoping to hear something from Lou Donaldson. She hoped to get a letter, postcard from Costa Rica. She hoped to get a text message or a phone call. Members of the jury, Lou Donaldson was nowhere to be found. So seeking closure, Ms. Baja went to the courthouse. She filed to have him declared legally dead. And she did apply to get that life insurance payout, members of the jury. And you will hear today from a life insurance investigator at that company. When Ms. Chris Renard takes the stand, she will tell you all about how her CEO said, we need to find a way, we need to investigate what went on here. She'll tell you that she investigated the circumstances around Lou Donaldson's disappearance, didn't find them suspicious. She'll tell you that she investigated the will that Ms. Cox got up here and told you was forged. She'll tell you that she didn't think it was forged. Members of the jury, Ms. Renard will tell you that her final piece of advice to her employer was that we should pay the life insurance policy. We should pay a $5 million life insurance policy. Now, at the end of today's trial, my co-counsel, Robert Fairbanks, is going to come up here, and he'll walk you through all of the evidence that you'll have heard over the course of the trial. I'm just going to ask you to keep in mind, members of the jury, that this is a case about a man who lived his life off the books until he went off the grid. And he wanted to make sure with that life insurance policy that he was left off the hook. Thank you.
Thank you, counsel. For the plaintiff, you may call your first witness.
Thank you, Your Honor. Plaintiff called Taylor Pride.
Taylor Pride, please take the stand. You are constructively sworn.
Hi, Mr. Pride. You and I have gotten to know each other a little bit, but would you please introduce yourself to the jury?
Yes, my name is Taylor Pride. My last name is spelled Pride.
Where do you work, Mr. Pride?
I work for my own firm, Taylor Pride Investigations.
How long have you owned your own firm?
Well, I started my own firm in 2016, so about 4 years now.
What is it that Pride Investigations does?
Well, I'm an investigator and a forensic document examiner. So we investigate a lot of different things, but we're mostly a private detective agency that gets hired to investigate particular documents and things like that.
What did you do before you owned your own business?
So before I owned my own business, I worked for the Pioneer Police Department. I was a detective there for 16 years.
Did you work any special type of units while with the police department?
Yes, for about 6 years, I worked in the economic crime unit, where I spent a lot of time investigating forgeries specifically.
Now, Mr. Pride, I want to talk to you about some of your certifications. Do you have any type of certification?
Yes, I am certified by the American Board of Forensic Document Examiners as a forensic document examiner.
What does it take to be certified?
Well, it's a four-phase assessment. You submit your credentials and 3 references. There's a proctored multiple choice exam. You have to successfully complete a practical case assignment, and then you submit to an oral board of review.
Do you have to keep this up annually?
Yes, I do have to attend annual 8-hour courses, and then I have to recertify with them every 4 years.
Now, Mr. Pride, without going into the details, did you come to a conclusion in this case?
I was actually able to come to a number of conclusions in this case.
What are some of the materials you reviewed to help you come to these conclusions?
So I reviewed a will that the defendant in this case presented as a legitimate will of Lou Donaldson. I examined the report of Chris Renard, who did an insurance investigation. I spoke to witnesses of that will, and also I looked at other documents and surrounding the circumstances of the disappearance of Lou Donaldson.
Did you use methods that are generally relied upon by other experts in your field?
Yes, I did.
Now, when regarding with handwriting, what are some of those methods you used?
So handwriting specifically, what I did is I would take, when determining whether a signature is authentic, which in this case, the relevant piece of information, it is a signature, I found other confirmed examples of Lou Donaldson's signature, and I compared those both to each other and then also to the signature on the alleged last will and testament of Lou Donaldson.
With regards to your investigation into his disappearance, what were generally some of the methods you used?
Well, I attempted to contact the sheriff's department. I reached out to witnesses. I spoke with Cam Donaldson, of course. I actually ended up sending someone from my office to Costa Rica to see if they could find him or in any way corroborate what Karen Baja had said.
Was this data and information that you used sufficient enough to help you come to your conclusion?
Yes, it was.
And did you reach your conclusion within a reasonable degree of professional probability?
Yes, I did.
Do you believe your testimony here today would help the jury understand the facts of this case?
Yes, I do.
Finally, Mr. Pride, have you ever been accepted as an expert in the judicial system here in Statesville?
Yes, I have.
How many times?
I have, I've been, let's see, 15 times since 2002.
I can understand it's a little hard to keep track with how many you've had. At this time, Your Honor, plaintiff would tender Taylor Pride as an expert in investigations and as an expert forensic document examiner.
All right, the tender's in investigations and forensic document examiner. Is there an objection or voir dire?
Without objection and no voir dire, Your Honor.
All right. Then that tender will be accepted and the witness will be considered an expert in investigation and as a forensic document examiner.
Your Honor, before I continue with this examination, my videos caught my eye. I seem to be flickering on my screen. Am I flickering on yours as well?
I thought you were at a dance party, but
Kind of a rave here. Yes, sir. I'm going to see
if you need to take a moment, that's fine.
May I?
Certainly.
I think that seemed to help a little bit.
Yeah, it stopped.
All right. May I proceed, Your Honor?
You may.
Mr. Pride, I apologize for the interruption. I'd like to talk to you about how you got involved in this investigation. Who hired you?
Well, I was hired by Cam Donaldson to look into the disappearance of her father, Lou Donaldson.
And at the time that Miss Donaldson hired you, when was the last time her father was seen?
Well, the last time her father was seen was August 17th of 2012.
Mr. Pride, are you aware of any sort of police investigation occurring regarding the disappearance of Mr. Donaldson?
Yes, I'm aware that there was some police investigation, but I haven't been able to get a hold of any of the police records from the sheriff's department.
Do you know if it's a closed case or what's happening with that case? Do you have any information about the status?
Yes, that is still an open investigation.
Now, Mr. Pride, I know you're aware we're here for a wrongful death lawsuit, and one of the elements for a wrongful death claim is that Lou Donaldson is dead. Throughout the course of your investigation, what has made you believe that, or do you believe that Lou Donaldson is dead?
Yes, I do believe that Lou Donaldson is dead. There's a number of things that I was able to look at and to make that determination. First, his personal bank account has not been touched since August 17th of 2012. Second, as I mentioned earlier, I sent someone to Costa Rica, which is supposedly where he had disappeared to on a private plane. And they were not able to find any traces that he had been in Costa Rica since 2012. I spoke to the witnesses and I examined this will, and I determined that the will was a forgery. So with all of these things combined, I came to the conclusion that Lou Donaldson is dead.
And are you aware of Mr. Donaldson's current legal status?
Yes, that's the other part of this, is that in 2017, Karen Baja had Lou Donaldson legally declared dead. So apart from the rest of the investigation, he is legally dead.
Now, Mr. Pride, I want to turn to and talk to you about what's been previously admitted as Plaintiff's Exhibit 2.
All right.
You'll give me just a moment. Mr. Pride, what is it that the jury's looking at right now on their screen?
Well, so this is a request for a restraining order that Lou Donaldson filed against Karen Baja on June 12th of 2012.
And what were Mr. Donaldson's stated reasons for filing this temporary restraining order?
Well, his reasons were
Objection,
that...
Your Honor, cumulative.
Counsel, your response to going over the particular document?
Your Honor, it's not cumulative. The jury has not heard the contents of this document. Mr. Pride is just simply testifying to what is already admitted as Exhibit 2 for plaintiff.
This is the first time that the jury has actually seen this document, and even though it is admitted and they will have it back for deliberations, it's certainly available for counsel to discuss at this first point in time. So the objection's overruled.
Mr. Pride, would you please tell the jury what are some of Mr. Donaldson's stated reasons for filing for this temporary restraining order?
Yes, so Mr. Donaldson was seeking a divorce from Karen Baja, but he did not feel safe around her, and he said that she had threatened to kill him.
Now, Mr. Pride, I would like you to pull up on your screen what's been marked as base number. Let me make sure I get this correct. 082196300014.
All right, I've got it.
What are you looking at?
I am looking at a supposed last will and testament of Lou Donaldson.
How are you familiar with this document?
Well, so this is the document that the defendant provided as the legal document. I was able to review the records and the records that were given to me by Cam Donaldson, also the records that I was able to find when I conducted my investigation.
And is this a true and correct copy of the alleged last will and testament?
Yes, this is a true and correct copy.
I'm sorry, Mr. Pride, I had some speaker interference. Is this a true and correct copy of the document you reviewed?
Yes, it is.
At this time, plaintiff would tender Plaintiff's Exhibit 3 to opposing counsel, and plaintiff offers Exhibit 3 into evidence.
Any objection to Exhibit 3?
No objections, Your Honor.
All right, Exhibit 3 will be admitted.
Permission to publish to the jury?
Granted.
Now, Mr. Pride, how many wills have you investigated?
Well, I mean, in the course of my time as a police officer, a police detective in my private practice, I mean, I've lost count. It's in the hundreds.
And when you investigated this particular will, what stood out to you?
Well, so there's a couple things that stood out. First is there's some language in the will itself that says if I should die or disappear, I had never seen that in any of the hundreds of wills that I have investigated over the years. It's also notable, it's worth pointing out that Karen Baja, who is the sole beneficiary of this last will and testament, is also one of the witnesses, the people that are supposed to confirm that it was signed by the person that it seems to be signed by.
Objection, Your Honor, substantially more prejudicial than probative as to Karen Baja being a signatory and that being notable.
Counsel, your response. I believe that's the 403 objection. So if counsel, your response.
Your Honor, yes, under federal rules of evidence, it is the probative value substantially outweighs any prejudicial effect. That Ms. Baja is not only the sole beneficiary, the sole executor, and she's also one purporting that this is his will, but she's also one of the two witnesses for this will here today.
I'm going to overrule the objection. I believe that this topic is ripe for cross-examination. The objection's overruled.
Now, Mr. Pride, I believe we were talking about the witnesses who signed this will. Would you please tell us one more time, what is it that was unusual about the signatures for the witnesses of the will?
So what was unusual here, and is that the person who is the sole executor and beneficiary of the will is also one of the witnesses. So that's just, it's unusual. You don't see it very often.
Mr. Pride, we're now going to show you what's been previously marked and admitted into evidence as Plaintiff's Exhibit 2 and Plaintiff's Exhibit 3 here on the screen. Would you please identify for the jury, where is the signature that is at the top of this document? Where is that signature from?
That is the signature from the restraining order that we were just looking at.
And where is this signature from the bottom?
That one is the signature on the will.
Would you please describe to us what makes Mr. Donaldson's signature distinctive?
So if you look at that top signature, there's a couple of features that are distinctive. He sort of double loops his O's. He uses very smooth motions to connect his words. He uses large loops on the L. It's also notable that the O, the second O in Donaldson, is what we call a lazy letter. It's a letter that people don't often, by the end of their signature, don't fully write the letters. And so that one sort of gets eaten in the signature. It's not fully formed.
And what makes the signature on the will different?
Well, so there's a number of features. So the D in the top signature, Mr. Donaldson always made the D with two quick strokes of the pen, but I can tell by the formation of the D in the second letter that it was a single stroke and the pen was fully removed from the paper and then placed back to finish it. It's also notable that the L in Donaldson does not have the large open loop I would have expected to see, and that the O, the second O in Donaldson, is fully formed in the signature on the will.
Mr. Pride, I now want to talk to you about your investigation into the disappearance of Mr. Donaldson. Did you have a chance to look into claims that he just vanished to Costa Rica?
Yes, I sent a member of my staff to Costa Rica to look into those allegations.
What did you learn?
Well, what I learned is that there was no evidence at all that Mr. Donaldson had been to Costa Rica since 2012.
Mr. Pride, I'm showing you what was previously marked and entered into evidence as Plaintiff's Exhibit 1. What is it that we're looking at here on our screen?
Well, so this is a statement from Mr. Donaldson's primary account. It's in fact the statement from the month that he disappeared.
Now, if we look at this document, how much money was in the account at this time?
Approximately $100,000.
And how much was withdrawn?
Actually, if you look at it, I mean, the last withdrawal is $940, but over the course of the month, it actually went up by about $500.
So you're saying that you see a lot of activity that was in this account?
Yes, but what's notable here is that the last withdrawal was on August 17th of 2012, which is the same day that Lou Donaldson disappeared. It seems unusual that he would leave $100,000 in the bank account if he left to go to Costa Rica.
Finally, Mr. Pride, were you able to come to a conclusion in this case?
As I mentioned, I was able to come to a number of conclusions. The first is that the signature on Lou Donaldson's will, supposed will, was forged. And in speaking to one of the other witnesses, Samantha Lane discovered that she had been threatened to participate. What's more, based on the
Objection, Your Honor, to the speaking to Samantha Lane.
Counsel, we'll constructively approach on this. There's the mention of this particular person. I know that we had that. This objection may be a little bit premature. If I can have defense counsel, Mr. Hajar, explain the objection. I know that you were just trying to get in there as soon as you could.
Yes, Your Honor. Thank you. I'm objecting to hearsay, Your Honor. The witness just testified that he spoke to Samantha, just testified about speaking to Samantha Lane, and we didn't hear any prior testimony about this speech, and this is in and of itself hearsay that should be inadmissible.
All right. Your response to that, Ms. Wayne.
Yes, Your Honor. Under 703, this expert is allowed to rely on hearsay. He wasn't going into the details of his conversation with Ms. Lane. He just said he spoke with her. And based off of that conversation, he came to the conclusion that she didn't actually witness the signing of this will. Like I said, Your Honor, under 703, he is allowed to rely on hearsay. And she does qualify as an unavailable witness under 804A5.
Here's what I'm going to do. Based on the foundation that we have, that is enough to talk about the conversation. I feel comfortable with that. And so I'm going to overrule the objection as to the conversation that he actually had with Ms. Lane. As far as the letter, there is no foundation for the letter or necessarily a reference into the letter. I don't believe that we have enough information there. And I would just ask for a limit that not be brought up. And if it is, that Mr. Hajar is allowed to make an objection again.
Yes, Your Honor. Mr. Pride, you were telling us you had a conversation with Ms. Lane.
Yes, I had a conversation with Samantha Lane, who is the second witness apart from Karen Baja on this supposed will. And my conclusion after having that conversation is that Samantha Lane did not in fact witness the signing of this will by Lou Donaldson. And so my final conclusion was that the will was forged. It was not authentic between that and the handwriting analysis. And finally, my conclusion is that Karen Baja was responsible for the death of Lou Donaldson.
No, pass the witness, Your Honor.
All right. Cross-examination.
Yes, Your Honor. Court's indulgence to construct the well.
Certainly.
Mr. Pride, I want to start by talking about your investigation into Lou Donaldson's disappearance. You started by going to the Pioneer County Sheriff's Office, right?
That's right.
They still consider the case active.
That's true.
So you were unable to get much information from them, were you?
That's right. They stonewalled me.
So you started conducting your own investigation.
Yes, I'm an investigator, yes.
Mr. Pride, you were hired 5 years after the events of all this occurred.
That's right.
You couldn't find Lou Donaldson's body.
No, though he was declared legally dead.
You couldn't find any DNA evidence of Lou Donaldson's death?
5 years out, it would be all but impossible.
You didn't even interview Karen Baja about Lou Donaldson's death.
Yes, I wasn't able to speak with her.
So let's talk a little bit about the evidence that you did find. Now, you found evidence that there was a restraining order filed, right?
Yes, that's right.
Mr. Pride, you don't know what happened in Lou Donaldson and Karen Baja's marriage after that restraining order.
No, but I do know that it was only 2 days from the time that he filed a restraining order stating that she threatened to kill him to the point where she claims that he signed a new will.
But, Mr. Pride, that you don't know, you don't actually know what happened leading up to that.
All I know is what Lou Donaldson put in that restraining order.
Now, I want to move on to talking about the will a little bit. You testified on direct that you believe that will is forged.
Yes, I do. It is my expert opinion that it is not an authentic will.
You did this by comparing Lou Donaldson's the signature on the will to known signatures from Lou Donaldson.
Yes, that was part of it.
Mr. Pride, according to you, signature that looks too different from a known sample might be a forged sample, right?
Yes, if it is too different, that's true.
And it can look different due to what you called quivering lines.
Yes.
It can look different due to other distinguishing marks.
Yes, slant, slope, things like that.
Mr. Pride, a signature that's 100% identical could also be a false one.
That's true. In fact, it being 100% identical is an indicator that it probably is false. But there's sort of a range here. So if it's 100% identical, it's probably false. But if it's too far away, that's probably also false. So it's not. Yes, it's not. I'm not looking for things that are exactly the same to authenticate a signature. Not that alone.
You're also looking for things that aren't too different to authenticate a signature. That's right, Mr. Pride?
Right. There's sort of a range where, when comparing signatures, that they are going to be considered authentic, but anything outside that range is not authentic.
I want to move on to some of the language that you described as suspicious language. You mentioned the language of "if I die or disappear" seems suspicious to you.
Yes, that's right.
Mr. Pride, you testified on direct that you've investigated hundreds of wills, haven't you?
That's correct.
Some of those wills have turned out to be real wills.
Yes, and none of the other wills had the language "if I die or disappear."
But some of those wills were forged wills.
Yes, that's right.
Neither the forged nor the real wills included any kind of language like that.
That's true.
Mr. Pride, you can't testify to why such language could have been included.
I can guess as to why, but I don't have any specific evidence as to why. No.
Mr. Pride, I'm going to finish off by talking about some of your conclusions. You concluded that Karen Baja had something to do with Lou Donaldson's disappearance.
Yes, that she caused Lou Donaldson's disappearance. Yes.
Mr. Pride, you couldn't tie Karen Baja to Lou Donaldson's location the night of the disappearance.
Not specifically, no.
No further questions, Your Honor.
Redirect.
No need for redirect, Your Honor. May this witness step down?
Yes, this witness is excused. And next witness by the plaintiff.
Your Honor, before we call our next witness, would it be okay if we got a time check on the amount of time left in plaintiff's case?
If somebody wants to pop in, I didn't want to catch you off guard. I know that we had a witness on the stand.
Of course.
Are the timekeepers?
Let me just take a moment to add up what I have, and then I'll see if the other witness was able to take time or not.
All right. So while they're doing that, kind of as a heads up, we had specifically planned and I had addressed that we would do it at the halftime point. I understand that you'd like to have the accurate keeping of time, but I'm going to let them calculate that, and let's go ahead and proceed, and we can do it right after this.
Of course, Your Honor, and I apologize. My time had messed up during it, but I'll go ahead and call it this time by way of video deposition testimony, Exotic Bob.
Cat sister, where you put your mister? Feed him to the lion's den. Hey there, cat sister, where you put your mister? Feed him to the lion's den. Hey there, I'm Exotic Bob. You probably recognize me as the owner of the world famous leopard camp, I See Spots. I want to thank you for your patronage over all these years. I'm currently a guest of the federal maximum security hotel system. Compliments of one Karen Baja, and that's who I'm here to talk to you about today. You see, it was 2 years, 2 weeks, and 2 days to the day that her husband was last seen alive. She and I was working on a highly illegal deal. It was illegal importing leopards and lions. Leopards was for her, leopards was for me, lions was for her. Now, we never worked together before, we never worked together since. But due to the severe illegality of the deal, we thought it best to work together, so we did. And at the end of that meeting, Karen Baja walked out of my office. She stopped, suddenly turned around, and she came marching back to my desk, and she leaned over and she looked me right in the eye, and she said, "Exotic Bob," that's me, Exotic Bob. She said, "Exotic Bob, I swear if you double cross me on this deal, I will do to you exactly as I did to my husband. There won't be no disappearance, no mythical flight to Costa Rica. She goes, your last supper will be you. I'll feed you to my kiddies just like I did him." And then she turned around and she walked out of my office. That's all I've got to say about that. Hey there, evil woman, where you think you're going? We all know where you've been. Hey there, evil woman, where you think you're going? We all know where you've been.
Your Honor, that's all the testimony we intend to offer from Exotic Bob.
All right. And that video will be available to the jury back for deliberation.
Your Honor, at this time, plaintiff calls Cam Donaldson.
All right, Cam Donaldson, please take the stand. You are constructively sworn.
Ms. Donaldson, would you please introduce yourself to the jury?
Hi, my name is Cam Donaldson.
Where are you from, Ms. Donaldson?
I'm from here. I'm from Pioneer, Statesville.
I want to talk to you for a minute about you and your relationship with your dad. Were the two of you close?
Very. I saw him every day at work for 20 years. I mean, he was my best friend, my dad, my mentor.
Where did the two of you work?
So I started working with him, as I said, 20 years ago. And then 11 years ago, when he founded Wild Wildlife, I worked with him there.
Do you still work at Wild Wildlife?
I don't.
Why not?
Karen fired me.
We'll come back to the firing in just a minute, but what was it like working side by side with your dad?
It was great. I mean, he taught me everything I know about the business. I ran the books. He said that I knew more about the business than he did. It was just the best way to live my life.
And I know this is hard, Miss Donaldson, but when was the last time that you saw your father?
The last time I saw my dad was August 17th, 2012.
Where were you on that day?
I was at work. It was a Friday. And the last time I saw him, he was, walking out the door into the day.
What happened then?
He turned to me and said, see you Monday or stop by Sunday night for dinner if you want to.
Did you ever get to have that Sunday dinner with your dad?
I didn't.
Ms. Donaldson, how has your dad's death affected you?
It's been really hard. You see someone every day, you talk to them, get advice from them, they're your shoulder to cry on, and then they're just gone.
And I know you're here seeking monetary damages. Why is that?
I know that nothing's going to bring my dad back, but he worked so hard to build this business and to build Wild Wildlife, his dream. And for Karen to do what she did and take that all away, somebody has to stand up and do something. That's why I'm here.
And is Wild Wildlife as a property something that you're trying to get back here today?
It is.
So other than working at the sanctuary, did your dad have any other hobbies that he enjoyed?
Yeah, he liked to fly his planes.
Knowing your dad, do you know if he required eyewear to fly his planes?
Oh yeah, he was as blind as a bat without his glasses. He couldn't read, he couldn't drive, definitely couldn't fly a plane.
Ms. Donaldson, I'd like you to pull up on your screen what has been marked as Bates number 08221 963-002. Will you let me know when you have that pulled up?
I have it pulled up.
What's depicted on this photograph that we're looking at?
It's a picture of my dad's glasses and his keys on the seat of his van.
How do you know that these are your dad's glasses?
I mean, the square shape, the thin wire, he's had those glasses since high school. I recognize them.
And is this photograph a fair and accurate representation of what your dad's glasses looked like at the time of his disappearance?
Yes, it is.
Plaintiff constructively tenders what has been identified as Lou Donaldson's glasses to opposing counsel, and at this time, plaintiff offers Exhibit 4.
Any objection to Exhibit 4?
No objections, Your Honor.
All right, Exhibit 4 will be admitted.
May we also publish it to the jury?
Granted.
Ms. Donaldson, when were these glasses pictured found?
They were found a week after the last time anyone saw my dad.
Having known your dad for so long, did you ever know him before to go on a flight and leave his glasses behind?
Never.
And when the last time you saw your dad on August 17th, did he have a big suitcase with him?
No, nothing like that.
Did he tell you that he was going on a trip?
Counsel, I've replayed that day in my head over and over again. He didn't say anything. There's no indication that he was going anywhere.
Do you remember any conversation about him going to Costa Rica even?
No, no mention of Costa Rica.
That's all I want to ask you about as far as this photo of the glasses goes. But I want to talk to you next about your relationship with your dad and the defendant before your dad disappeared. How was everyone getting along?
Not great. My dad filed a temporary restraining order against Karen.
Do you have any knowledge as to why your dad filed that temporary restraining order?
So they had gotten into an argument about a couple months before the last time anyone saw him, and she yelled, "I'll kill you."
Is this the only time that you'd seen the defendant yell those sorts of things at your dad?
No, I saw her arguing with my dad just 2 weeks before the last time I saw him.
Where were you when this argument 2 weeks before he disappeared was happening?
I was at the office at Wild Wildlife, and just outside the office door of my dad's office. That's where he and Karen were.
Could you hear them clearly from where you were sitting?
Yes, definitely.
Were you able to see the two of them during this argument?
I wasn't. The door was closed, but I saw them afterwards.
I want you to describe what the defendant looked like after that argument.
So Karen she stormed out of the office. Her face was red, she was angry, didn't even acknowledge me, just stomped right past me.
And what about your dad? What were his reactions like to this argument?
So he followed shortly behind, and it was unsettling. He was pale, his hands were shaking, his eyes were big. That's my dad, right? I've never seen him like that. He's my protector, and he just looks so scared.
How long after the two of them had argued did you see your dad look like this?
Immediately after.
Did your dad say anything to you after the defendant stormed out?
Yes, he did.
Ms. Donaldson, I want you to look into the camera and tell the jury exactly what your dad said to you on that day.
Objection, Your Honor. Calls for hearsay.
Counsel, your response to hearsay.
Yes, Your Honor. We've established the predicate here that this was an excited utterance by Lou Donaldson immediately after a very aggressive confrontation with the defendant. Additionally, Your Honor, under 804, Lou Donaldson is an unavailable witness due to his death or disappearance under 804, 4 and 5. And additionally, under 804B, B6, he's unavailable because of actions, because he was killed by the defendant. And because of that, this is an exclusion and an exception to hearsay under those two rules.
Do you have any response to that, Mr. Fairbanks?
Yes, Your Honor. The witnesses testified that these arguments were not uncommon. These marital disputes she had witnessed on multiple occasions does not reach the level of a startling event or condition to meet the bar for an excited utterance.
Any response to the other aspects of the 804 arguments?
Yes, Your Honor. The declarant was not cross-examined on this statement. All we have is the witness's word that it occurred, and I do not believe that it falls under the 804 exceptions.
All right. I'm going to overrule the objection. I believe that there has been enough foundation for the excited utterance, and I believe that it would come in under that particular point. So objections overruled.
Ms. Donaldson, I was asking you about this argument 2 weeks before your dad disappeared. I want you to look into the camera and tell the jury exactly what your dad told you on that day.
He said, if anything happens to him, to tell the police to look into Karen because she will be responsible for his death.
Let's switch topics for a moment. Do you know if your dad had a will?
He did.
How do you know this?
We talked about it. He kept it in a lockbox in my office desk.
Do you know where that lockbox is now?
No, I don't.
Why not?
The last person that I saw who had the lockbox was Karen.
Let's break that down just a little bit. When did you see the defendant with this lockbox where your dad kept his will?
36 hours after the last time anyone saw him. Early Sunday morning, August 19th at 6 a.m.
Will you tell us what you saw that day?
Yeah, so the alarm had gone off at Wild Wildlife and I lived close. I hopped in my car, a police officer followed me. We got to the sanctuary, the front lock was cut in half and the back gate was broken. Out walks Karen holding the lockbox, followed by some stranger who I'd never seen before holding lock cutters, bolt cutters. And she had this big grin on her face like the Cheshire cat. It was unsettling.
And just so we're clear, on the day that you saw the defendant with the lockbox, had it even crossed your mind yet that your dad might be dead?
No, it was early Sunday morning. I was supposed to go to his house that night for dinner. At this point, no one was even saying that he was gone.
Did you ever see the lockbox again after that day?
No, I didn't.
Ms. Donaldson, do you know what will was probated in your dad's estate?
Some document that Karen just brought up out of the blue, out of nowhere.
And we've heard testimony about that will today. Do you remember what date that will was signed?
It was signed June 14th, 2012.
So on June 14th, on the days and months leading up to that time period, how was your relationship with your dad?
It was great. We were working side by side every day.
Did he still confide in you during that time?
He did. We talked all the time.
Were you having any kind of arguments or disputes with him during that time period?
No, not at all. Nothing like that. We were getting along great.
Was anyone?
Karen, they were arguing.
Pass the witness.
Cross-examination.
Yes, Your Honor. May I be given a moment to switch my camera output?
Certainly.
Ms. Donaldson, I know this is hard for you, but I'd like to start by talking about the relationship you had with your father that you've touched on briefly here today. You ran the day-to-day of his business.
That's right.
Scheduled his meetings,
Yes.
wrote the checks,
Yes.
answered the phones,
Yes,
ordered the supplies.
that's right.
You also handled the financial records.
Yes,
So I think in your words, you said you ran the books.
right.
So you were an important part of his business.
I guess so.
But your father never told you about a mistress in Costa Rica.
I've never heard anything about that.
So you weren't aware of any mistress in Costa Rica.
No.
Well, Ms. Donaldson, I'd like to ask you about some of the other things you aren't aware of. You aren't aware of your dad having any US bank accounts other than the one that was shown in evidence today.
Objection, Your Honor. Lack of personal knowledge.
Counsel, your response with where you're going with this.
Yes, Your Honor. I am the plaintiff has made an argument that the fact that the bank records, there have been no debits on the bank records admitted into evidence today. I just want to clarify with the witness who has testified that she ran her father's books is not aware of any other potential bank records which may or may not have been debited recently.
Overrule the objection. I'll give you a little leeway. Go ahead.
Thank you, Your Honor. So you aren't aware of your dad having any US bank accounts other than the one that was brought into evidence today?
No, I ran the business's books.
And you don't know if he had any foreign bank accounts?
No, I don't.
Any stocks?
Not that I can say today.
Any other investments?
Again, I ran the books for the business.
You don't know if the business had any real estate which your father kept off the books?
Not if it wasn't in the books, then I wouldn't know about it.
Well, I want to talk to you about some of the stuff that you know your father kept off the books. You know that he bought and sold planes all the time.
Yes.
And you know that most of the time he did not register those planes.
He didn't register his flight plans.
Did he register the planes themselves?
I don't recall. I'm not even sure how many he had.
So you're not sure how many planes your father owned?
No.
And you've testified that your father sometimes flew without logging a flight plan.
That's right.
And you're also aware that he flew without a valid pilot's license.
That's right.
And you don't know all the different places your father has flown before.
I mean, he told me about his flights.
So if your father chose not to tell you, you don't have any way of knowing whether or not your dad flew to Costa Rica the night he disappeared.
Objection, Your Honor. This is going into a hypothetical question, and this is a lay witness. So this would be outside of her personal knowledge and ability to answer.
Counsel, your response with where you're going with this.
Yes, Your Honor. The witness has testified that she knew that she was told by her father where he was flying. And she has testified that she did not believe that on the night he disappeared, he flew to Costa Rica. I'm trying to elicit a response as to how she would have known that had her father not told her.
Based on the direct examination and some of the areas that they went into as far as the details of what this witness knew and the close relationship that she had with her father, you can certainly ask a question like this. I'll give you a little leeway. Overruled.
Thank you, Your Honor. May I repeat myself?
You may.
So if your father chose not to tell you, you don't have any way of knowing whether or not your dad flew to Costa Rica the night that he disappeared.
In your hypothetical, no, I wouldn't.
Ms. Donaldson, I want to finish by talking about your accusations against Ms. Baja. You hate Ms. Baja.
For what she did to my dad? Yeah.
You hate her so much that you've said, I hope she's attacked and eaten by one of her tigers.
Counsel, what she did to him and my family? Yeah.
So your allegations as to what she did affected you so much that you hired an investigator to look into your father's disappearance.
I hired an investigator, yes.
And you hired that investigator in July of 2017.
That's right.
And your father disappeared in August 2012.
Yes.
So you waited roughly 5 years to hire an investigator to look into your father's disappearance.
You know, you wait for the police to do what they're supposed to do, and then Karen decided to declare him legally dead. That's when I hired Mr. Pride.
So you hired Mr. Pride that same year your father was declared legally dead.
That's right.
And your father was declared legally dead in August of 2017.
That's right.
So you hired the investigator about 1 month before your father was declared legally dead.
I couldn't let Karen kill him again.
And after your father was legally declared dead, the insurance company could pay out his life insurance policy.
Yes.
And you were not to receive any part of that policy.
That's right.
No more questions, Your Honor.
Redirect.
Briefly, Your Honor. Ms. Donaldson, you were talking on cross-examination about why you waited 5 years to hire an investigator. If you knew that someone on the police force was related to the defendant, would you have waited that long?
No, I wouldn't have.
Your Honor, we have no further questions for this witness. May she be excused?
Yes, witness may be excused.
At this time, plaintiff has no further witnesses to call, and we rest our case.
All right. We've been going for a little while here. At this point, we will address any halftime motions after a brief break. What I'd like to do is, I know it'll go by quickly. We'll give 10 minutes. So my clock says 7:47, so I'm sure it's probably going to switch here in just a second. But at 7:58 sharp, if not earlier, I'd like to start back up again. And we'll address the time matters for how much time there is at that point. We'll do a time check, and we will also jump into any motions at that time, and then start with the defense case in chief. All right. On that, we're on recess. Okay, I see that the parties are back, and we can just discuss and make sure that the time, we can certainly discuss that, is the scoring jurors if they're still settling in the next couple of minutes. So I saw that a chat had gone out regarding the time. Is everyone okay with the time that we have at this point? Does that seem
Yes,
appropriate?
Your Honor.
Okay, great. So if the time is all right, let's give it just a few more seconds. And just take care of this. All right, well, we're close enough. I warned that we'd probably start just a little bit early. So as far as any motions, are there any motions at this time?
Yes, Your Honor. The defense would like to move for judgment as a matter of law in favor of the defense and against the plaintiff.
All right. If you'd like to go ahead and put forth that argument.
Yes, Your Honor. The plaintiff, at the conclusion of their case in chief, has presented no evidence as to exactly how they posit Karen Baja in fact committed this alleged crime. They have not presented any. Their own expert testified that he couldn't place Karen Baja at the location of Lou Donaldson the night that Lou Donaldson disappeared. The plaintiff herself testified that she only ran her father's business records. And so the bank record that plaintiff has relied on at the crux of their case does not cover anything beyond the business, according to the plaintiff's testimony. And so no reasonable juror could look at a business-only record and look at an inability to link the defendant to the allegedly deceased location and find that in fact the defendant caused that death, or even that there was a death necessarily.
All right, response.
Yes, Your Honor. First, Lou Donaldson has been determined legally dead, which is Taylor Pride testified to, so we have met that element of our cause of action. Additionally, Your Honor, as the federal rules of evidence and the federal rules of civil procedure tell us, circumstantial evidence is no different as far as the scales from direct evidence. We are not required to have direct evidence of how Karen Baja killed Lou Donaldson because we have all of the circumstances here telling us that she did it, which is what our element in our cause of action in Statesville requires us to prove. Your Honor, we've shown you that there's a forged will, that she had arguments. She threatened to kill him and threatened to kill other people, including Exotic Bob. She disclosed to Exotic Bob how she killed him, which was feeding it to the tigers, although we don't even have to prove that to meet our element of the cause of action here. And additionally, Your Honor, there's other circumstances that you've been presented here today, like Cam Donaldson stating from this argument that Lou Donaldson testified that if anyone did it, it was Karen Baja. All of these circumstances are more than legally sufficient to meet our burden to bring this case to a jury. And so we ask this court to not grant that judgment as a matter of law.
All right. Considering the standard within this for the halftime motion, I'm going to deny the motion, well argued by both sides, and we will proceed with the defense case in chief. Are you ready to call your first witness?
Yes, Your Honor. The defense calls Ms. Karen Baja.
All right, Ms. Baja, please take the stand.
And
You are constructively sworn.
I'll quickly switch videos, Your Honor.
Certainly.
Ms. Baja, I'd like to begin by letting you tell the jury a little bit about yourself. Could you please introduce yourself to the jury?
Yes, my name is Karen Baja.
And what do you do for work, Ms. Baja?
I run the Big Cat Sanctuary, Wild Wildlife. We take in leopards and lions and tigers and care for these gorgeous, beautiful animals.
And how are you connected to the plaintiff?
She is my stepdaughter.
I'd like to talk to you about the relationship you had with Lou Donaldson and your stepdaughter. Could you please tell the jury how you and Mr. Donaldson met?
Yes, it's a wonderful story. I was hitchhiking and Lou just came out of nowhere. He was my Prince Charming, and it was just a classic love story. The rest is history.
And how did the plaintiff treat your relationship with Mr. Donaldson?
She never liked me. We just never clicked despite my best efforts.
What, if anything, did you do that might have contributed to a poor relationship with your stepdaughter?
I didn't do anything. I came from a fairly humble background, and I think that really did not sit well with Lou's family. And as I said, despite my best efforts, Cam and I just could never quite click.
Other than the friction between you and the plaintiff, were there any other issues with your relationship with Lou Donaldson?
Yes, as our marriage went on, his off the books lifestyle became really difficult. He was a secretive guy, and it had its strain on us.
I want to talk a little bit about what you mean by off the books. So what is that phrase? How are you using that phrase?
Well, he was always coming and going, and he didn't really like to tell anyone about his whereabouts or his plans, and it became really tough.
I'd like to talk a bit more about the difficulties that came from Mr. Donaldson's off the book lifestyle. Did you ever bring up your concerns to him?
Yes, we were struggling through it, but we were fighting a lot. And at one point, Lou requested a restraining order, but the court denied it, and we were working through our issues.
So you said you were working through your issues. Were you able to ever actually fix them?
No, Lou had a mistress, and we were working on all of these problems, but then he just fell off the grid.
I want to turn to that mistress you mentioned. Did you know anything about his mistress?
Only that she lived in Costa Rica.
To your knowledge, did Mr. Donaldson visit her in Costa Rica?
Oh yeah, he flew there all the time.
To your knowledge, how did he get there? Did he buy a plane ticket?
Oh no, he flew his own planes. It was a hobby of his. So he would take trips to Costa Rica on his plane.
Are there records of those trips?
No, Lou's pilot's license was suspended, so he would fly without logging his flight plans.
Well, what kind of plane did he fly?
I couldn't even tell you. He had so many, and he was buying them and selling them, so I don't know.
Well, Ms. Baja, how did you know when he was flying to Costa Rica?
I mean, often I wouldn't. As I said, he would just pick up and leave for a business trip or a personal trip without really telling anyone. But I mean, he always came home until the last time.
I'd like to turn now to that last time, the night Mr. Donaldson dropped off the grid and disappeared. Where were you in the early morning hours of August 18th, 2012, starting around 1 a.m.?
I was at home.
What were you doing at home that morning?
One of our tigers had just given birth to this incredible litter of kittens, but she abandoned them, so I took it upon myself to care for them. But I realized that we had run out of formula, so they desperately needed that, and I left to go get it for them.
Were you able to get them that formula?
I was, yes.
Once you got the formula, what did you do next?
Well, on my rush to get out of the house to get this formula, I had forgotten my phone. So when I was driving home, my car broke down. And fortunately, I was able to flag someone down, and I called my brother, who was able to pick me up. He's a sheriff's deputy who was working that evening.
What time did you call your brother?
This was around 3 a.m.
Miss Baja, why wouldn't you call your husband for a ride?
I didn't know where Lou was, and I knew I needed to get back to the Tiger Cubs. So my brother seemed like the obvious choice. He was working, he's reliable, and who knew what Lou was up to?
What happened after your brother picked you up?
He checked out my car to see if he could get it running, but he wasn't able to. So he just drove me home and dropped me off, and I was able to get back to the babies.
Do you remember the time when he dropped you off?
Yes, it was around 3:45, 4 in the morning.
What happened then once you were home?
Oh, I went straight to the Cubs, and I was able to feed them their formula, and they've made a spectacular recovery.
What did you do the rest of that day?
I cared for these Cubs. I mean, it's a lot of work.
Did you see your husband that day?
No, I did not.
What did you do the next morning?
By then, I hadn't heard from Lou for a while, and I just had this feeling. So I went to the Wildlife office just to make sure I could get in and that everything was okay. I don't trust Cam, and I had to go make sure everything was all right.
I want to talk a little bit more about this feeling that you said you had. When you say you had this feeling, what was it in relation to?
I just had to make sure that the office was okay.
Why were you so concerned about the office this particular day?
As I said, I didn't trust Cam, and Lou I hadn't heard from him, and I just had to go there. I felt it.
Would you have normally heard from Lou at some point?
Yeah, I mean, he would always leave instructions or messages when he was leaving. So, yeah.
I want to talk to you now a little bit about what happened to Mr. Donaldson when he dropped off the grid. I know this is difficult, but did you have Lou Donaldson killed?
No, it's just ridiculous.
Do you know what happened to your husband?
I don't, and it pains me every day. He might be off in Costa Rica. He may have had an accident. I have no idea, but I just hope that he's okay wherever he is.
Miss Baja, if you don't know what happened to him and you hope he's okay wherever he is, why did you petition to have him declared legally dead?
As the days turned into weeks, turned into months, turned into years, I just couldn't handle the uncertainty anymore. It had been 5 years and I hadn't heard a word from him. I just needed to do this for closure and try to put this tragedy behind me. And to be perfectly honest, Cam just hasn't made it any easier.
Miss Baja, have you seen a copy of your husband's will?
Yes, I have.
Based on your understanding of your relationship with your husband, do you know why the will contains the language, "if I should die or disappear"?
I mean, Lou wrote the will, but...
I'm sorry, Your Honor, I think my computer delayed there. I said objection, cause for speculation.
There's an objection. Counsel, your response.
Yes, Your Honor. This was a long time marriage. Miss Baja and her husband spent a lot of time together. She was in a position to make observations for the length of that marriage. She's testifying now based on those observations. She's speaking to her observations based on rational perception. So she's offering testimony to explain why this language would be included in the will.
Counsel, do you have a response with that, the particular phrase?
Yes, Your Honor. My objection is that this witness doesn't know what was going in the mind of Lou Donaldson, even if he did write this will, which, as you know, is being contested here today. But she has no understanding of what his thought process was or would have been, and she can't speculate as to what was going through someone else's mind.
I'll give you a little bit of latitude with this. I'll overrule the objection. You may proceed.
Thank you, Your Honor. May I repeat the question?
You may.
Based on your understanding of your relationship with your husband, do you know why the will contains the language, "if I should die or disappear"?
As I said, Lou wrote the will, but I know him, and I think it's his way of making sure that myself and our animals were taken care of, and he could just be off the hook.
What do you mean, Ms. Baja, by off the hook?
Based on how things were going, despite my best efforts to salvage our marriage, I think Lou wanted out. And this was his way of making sure that even though he got to be off the hook, that we were still going to be okay.
And do you feel okay?
I do, but if I could trade it all, the insurance and even the animals, just to get Lou back, I would.
No more questions, Your Honor.
Cross-examination.
Yes, Your Honor. Ms. Baja, you just testified that Lou wanted out of your marriage. Yes?
By the end, it seemed as such.
And that Lou would just take off randomly, right?
Yeah, that's what he tended to do.
He wouldn't file the flight plan.
Sometimes he wouldn't.
He would just go without you knowing, right?
Yeah, he tended to do that from time to time.
But it sounded weird that on this one particular night, he did what he always did, as you've just testified on direct, that it was just out of the ordinary, correct?
No, he would do that all the time. It seemed pretty standard.
Sorry, maybe my question wasn't clear. On direct examination, you testified that he would just take off without telling you, right?
Yes.
But on this particular night, when he just took off without telling you, this night was strange, correct?
It didn't seem that strange. I mean, by that Sunday, I had a feeling that something was off, but.
Well, let's talk about that. You had a feeling that something was off, right?
Yeah, I just didn't trust Cam.
Well, Ms. Baja, we're right now talking about your relationship with your husband. You had a feeling that something was off with your husband, correct?
Yeah.
Even though you testified that he was just doing his normal behavior.
Yeah, I can't explain it.
Well, Ms. Baja, I now want to talk to you about something else. You're the one who told the police that he could possibly be in Costa Rica, right?
Well, that's where his mistress was, so I figured might as well check.
And you told the same sheriff's department that's investigating this case, right?
Yes.
The one your brother works for?
Yes, that's right.
The one your brother was working actually as a sheriff's deputy the night Lou Donaldson went missing, correct?
Yes, he was on duty that night.
Ms. Baja, I do want to talk to you. When you have someone declared legally dead, that means you can file for their life insurance policy, right?
Yes.
And you did.
Yes.
You got $5 million, right?
Yeah, that's what his policy was.
And when you have someone declared legally dead, you can probate their will, right?
Yes.
And you probated his will.
Yes.
Now, the will you probated was signed allegedly on June 14th of 2012, right?
That's what the will says, yes.
And that's just 2 days after your husband filed a temporary restraining order, correct?
Yes, as I said, the court dismissed it and we're working through our problems.
Yeah, and 2 days working through your problems of him saying that you threatened to kill him. He left you everything?
Yes.
It took 2 days to work through your problems when he said he wanted a divorce, that he would leave you everything he owned?
Marriage is a marriage, and the dynamics of our relationship are something that only Lou and I could know. So yes.
And Ms. Baja, it took 2 days to work through your relationship when he said he was afraid of you.
Yes. Yes.
No further questions.
Redirect.
No redirect, Your Honor.
All right. This witness is excused. Next witness from the defense.
Yes, Your Honor. At this time, the defense calls Ms. Chris Bernard to the stand.
All right. Ms. Bernard, please take the stand. You are constructively sworn.
Could you please introduce yourself to the court?
Yes, my name is Chris Renard.
Ms. Bernard, what do you do for a living?
I'm an investigator as well as a forensic document investigator.
What was your education prior to working?
Well, I received a bachelor's degree a BA in criminology from Summit College in 1996. And then I graduated from the Statesville Police Academy in 1997.
Did you actually work as a police officer after completing your training at the academy?
Sort of. I actually worked for the state's crime lab as a forensic document examiner for 3 years. So I was never actually like a police officer on the streets, but I worked for the police.
And does that require any kind of additional certification, that forensic document work?
Yes, I was certified by the Board of Forensic Document Examiners.
Now, you also mentioned that you're an investigator as well as a forensic document examiner. What do you investigate?
So I currently work for the Summit Life Insurance Company. I investigate possible fraud claims with insurance policies.
How long have you worked with the Summit Life Insurance Company, Ms. Renard?
20 years.
Does that investigation work you do with them require any additional training?
Yes, it does. I attend annual training workshops as well as continuing at my education for both forensic document examinations as well as fraud investigations.
Have you ever testified in court about this work in the past?
Yes, I've testified 25 times. One time I testified for the prosecution, and then I've testified 24 times on behalf of our insurance company.
Ms. Renard, were you employed by Ms. Beja in today's case?
No, I was not.
But were you asked to investigate this case?
I was.
Who asked you to investigate it?
So my employer, the CEO of Summit Life Insurance Company, asked me to investigate.
And what did you review in the course of your investigation?
So I reviewed several things. First and foremost, I reviewed Lou Donaldson's last will and testament. I reviewed the life insurance policy that Lou Donaldson had that provided a known sample of his signature. I looked at Mr. Donaldson's driver's license again to find a sample. And then I was able to conduct some personal interviews with Samantha Lane as well as Karen Baja. And then I was able to speak to a contact I have in the sheriff's department regarding the investigation into Mr. Donaldson's disappearance.
Is all of this information sufficient to enable you to come to a conclusion?
It is.
Is this the kind of information that a fraud investigator and a forensic document examiner would rely on?
It is.
Ms. Renard, let's talk a little bit about the methods that you use. Could you tell us a little bit about how you analyze all of this evidence?
Yes, of course. So when looking at the authenticity of a will, the first thing you want to do is to look at the signatures and determine if it's authentic or not. So that's exactly what I did. I took a look at Mr. Donaldson's signatures that were provided in those samples to determine the authenticity. You do that by looking for similarities and differences in the characters in those signatures. So some of those characteristics would be loops, strokes and stroke direction, curves, legibility of the signature, any angles to the letters, embellishment to the signatures, and then the capitalization of certain letters.
Are these methods standard in the field of forensic document examination and insurance fraud investigation?
They are.
Were you able to apply them reliably to all of the information you collected in this case?
I was.
Your Honor, at this time, the defense tenders Ms. Renard as an expert in insurance fraud investigation, as well as an expert in forensic document examination.
Any objection to the tender or voir dire?
Your Honor, we have no objection to the tendering of her as these expertise that he's mentioned. However, we do reserve our right to object to any testimony that she may offer as to general private investigative work, where she can't offer any testimony that a lay juror would not be able to come to the same conclusion themselves.
Right. You can certainly raise whatever objections you see fit, but with that record being made, I will accept the tender. It was as an insurance fraud investigator. Is that correct?
Yes, Your Honor, insurance fraud investigator and forensic document examiner.
And forensic document examiner. Great. I just want to make sure that I had it correctly. All right. The witness is now deemed an expert in those particular areas, and you may proceed.
Ms. Renard, I want to get a little bit into the work you did for this case. What exactly did your CEO ask you to investigate?
So I was asked to determine whether or not...
Objection, Your Honor, as to hearsay to the statements of the CEO.
Counsel, your response to hearsay.
Your Honor, there is no truth inherent in the questions that the CEO is posing. The CEO is posing questions because the CEO wanted the truth that Ms. Renard would be investigating. These aren't statements being offered for any truth asserted in them.
May I respond, Your Honor?
You may.
As to the questions by the CEO specifically, may I be constructively heard outside the presence of the jury?
Yes.
In the report that Chris Renard proffered, she states that the CEO asked her to look into certain circumstances, and the fact that she's offering these statements as whether or not she did them goes to show that Ms. Renard did believe the truth of these statements, that she was to look into them in certain parts of the investigation. And because of that, these statements are being offered for the truth of the matter of what the declarant stated.
I'm going to overrule the objection. I believe that this is basically contextual. It's also could be considered a command, could also be considered a question, which may not be hearsay statements at all. I'm going to give some latitude. Overruled. You may proceed.
Ms. Renard, what exactly did your CEO ask you to investigate?
Yes, so my CEO wanted me to determine whether or not Summit Life Insurance Company was required to pay Mr. Donaldson's $5 million insurance policy to Ms. Baggia.
And why did your CEO want you to investigate that?
Well, he wanted me to look into whether or not Ms. Baggia was involved in Mr. Donaldson's disappearance, whether or not she killed him, and whether or not she forged his will. If either of those circumstances had actually happened, we wouldn't actually be required to pay out that $5 million policy.
Were you able to come to conclusions about those two things?
I was, yes.
Nope. I want to take those one at a time, Ms. Renard. Your Honor, at this time, permission to have my co-counsel share a blank demonstrative that's going to be created as the witness testifies to aid the jury in understanding her testimony.
Certainly.
Ms. Renard, I want to start with the first of those questions that you were asked to investigate. Do you think that Ms. Baggia killed Mr. Donaldson?
I do not.
And why is it that you think that, Ms. Renard?
Well, for starters, the sheriff's office never charged or
Objection,
even...
Your Honor. May I be heard constructively outside the presence of the jury?
Yes, and just for further record, any of the objections after the initial objection are constructively heard outside the presence of the jury.
Yes, Your
You may
Honor.
proceed.
Ms. Renard is about to go into statements that she heard from the Sheriff's Department. So first, we object to these statements being hearsay. However, what Ms. Renard is about to testify to are to the conclusions and investigations that the Sheriff's Department did. That means that the Sheriff's Department has a report on this investigation, and under the best evidence rule, opposing counsel would be required not to present just the contents of this report, but to present the report itself that the police and the Sheriff's Department made as to their investigative findings for the defendant.
Response?
Your Honor, if I may proffer, the initial testimony that was about to be elicited from this witness is that that Ms. Baja has not been charged, nor has she been listed as a suspect. Those are both matters of public knowledge. This witness can testify to them. As a direct observation, charging decisions are made public, as is the fact that the sheriff's office has not listed Ms. Baja as a suspect. As for any other testimony that would be elicited, that testimony has not yet been elicited. No direct hearsay testimony has been elicited yet. And so I would simply not respond.
May I respond, Your Honor?
Briefly, yes.
As to the fact that these may or may not be public records, if they are public records like opposing counsel is asserting, that means that they would fall under the best evidence rule, which would require opposing counsel to not present the statements of what Mr. Nard believes the police said, but instead to actually present the report or the public record of the police themselves. Additionally, Your Honor, we do believe that this witness is going to go into hearsay statements from the Sheriff's Department, which is why we constructively objected outside the presence of the jury to handle it preemptively.
Understood. And it's a good objection, but overruled. You may proceed.
Ms. Renard, going back, why is it that you don't think Ms. Baja killed Mr. Donaldson?
Well, like I was saying, for starters, the sheriff's office has never charged or even listed Ms. Baja as a suspect. That's common knowledge.
Ms. Renard, were you able to get any other information from the sheriff's office?
Unfortunately not, because that investigation is still classified as active. The Sheriff's Department has been very reluctant in releasing any evidence.
So were you able to get any other evidence to help lead you to this conclusion?
Eventually I was. I do have a contact at the Sheriff's office, and I was able to learn—
Objection, Your Honor. At this time, we re-raise our hearsay objection that we mentioned a moment ago.
Counsel, your response to hearsay.
Your Honor, in this case, I would raise 703. During the process of certifying Ms. Renard as an expert, she testified that amongst the materials she reviewed were these comments that she gained from somebody at the sheriff's office. When I asked Ms. Renard if these are standard materials used in the process of investigating, she testified that they are in fact standard materials, and all of those are part of her credentials as an expert witness. Based on that, it would be substantially more probative than it would be prejudicial for the jury to hear this underlying evidence that allowed her to conclude that, in fact, she believes that Ms. Baja did not kill Mr. Donaldson.
Your Honor, may I respond?
No, I've heard enough. The objection's overruled. This witness may testify. You can certainly bring these points up on cross-examination. You may proceed.
So, Ms. Renard, you mentioned that you had that contact at the sheriff's office. What were you able to learn from them?
I learned two things about their investigation.
What was the first thing that you learned, Ms. Renard?
The first was that Ms. Baja had an alibi for at least some of the time that covered the time period of Mr. Donaldson's disappearance.
What was the second thing that you learned?
But the sheriff's office didn't seem to suspect any sort of foul play based on their investigation.
Ms. Renard, I want to move on to some of the conclusions that you had made about the will. Did you think the signature of Lou Donaldson on that will is genuine?
I did.
Ms. Renard, why do you think that signature is genuine?
Well, for a few reasons. The signatures were sufficiently close enough that it could have been a genuine signature, and they weren't— I'm sorry, was there an objection?
No, Your Honor, there's no objection.
Sorry, I must have heard something.
I heard something too. That's fine. In this format, that's fine.
So, like I was saying, the signatures were sufficiently close enough that it could have been a genuine signature, but they weren't different enough for me to conclude that it was a forgery.
Ms. Renard, could you remind us what you look at when you try and determine whether or not a signature is genuine?
Of course. So I'm looking at those characteristics of the letters that are in the signatures. So things that you look for are loops, stroke and stroke direction, curves, the legibility of the signature, angles of the letters, any embellishment to the signatures, and then the capitalization of certain letters.
Ms. Renard, what are some things that can cause a difference between any two given signature samples?
There are a number of things that can cause a difference in signatures. a difference in age between when signatures are made, any changes in health, the care that someone takes when signing a document, the writing instrument that's used, a pencil versus a pen, even something as simple as the person signing it wanting to do something different, being in a hurry to get through that signature. Those are all possibilities of why a signature may not look identical.
Do you know if any of those were present in Lou Donaldson's signature on the will?
I do not know, because I just did not have a way of checking to see if any of those reasons were present or absent.
Ms. Renard, did you do anything else to verify whether or not you thought that signature was genuine?
I did. I was able to contact the witnesses who signed that last will and testament to verify its authenticity.
Who was the first witness that you contacted?
I contacted Samantha Lane.
Did Samantha Lane verify her signature on that will?
She did.
What about the second witness you contacted? Who was that?
Well, that was Ms. Baja.
Was Ms. Baja able to verify her signature on the will?
She did.
Ms. Renard, I want to just talk a little bit about the final conclusions that you gave to your employer. What were you able to conclude about the signature on that will?
So I concluded that the signature on the will appeared genuine, and it was verified by both witnesses to the signing.
What were you able to conclude about Ms. Baja's involvement in the circumstances, and Ms. Baja's involvement in Lou Donaldson's disappearance?
That she was not involved.
So what was the final conclusion that you gave to your employer after all of this investigation?
I advised our CEO that we should pay out the life insurance policy to Ms. Baja.
No further questions, Your Honor.
All right, cross-examination.
Yes, Your Honor. Ms. Bernard, I just want to start out by clarifying one thing. You testified on direct examination how it was an order from your CEO to investigate this case, right?
That's correct.
It was an order that came from your CEO because she told you that she believed that Karen Basha killed Lou Donaldson, right?
I believe that was one of her reasons.
Objection, Your Honor. Hearsay.
Counsel, your response to hearsay.
Your Honor, this falls under 703 as this witness is permitted to rely on hearsay statements. Additionally, Your Honor, in direct examination, the discussion as to whether the statements from the CEO were commands or questions or even were hearsay were determined not to be hearsay. And direct examination opened the door for us to discuss the other statements that Mr. Nard relied on from the CEO.
Counsel, your response.
Your Honor, on direct examination, I simply asked her why she was asked, what exactly she was asked to investigate by her CEO. That could certainly fall under a command or a question. Somebody superior to you up in the corporate ladder asking you to do something or ordering that you do something. However, the CEO's personal opinions as to the reasoning behind that investigation does not fall under an order or a question. That's simply the CEO's personal opinion. And opposing counsel is now attempting to bring it in under as hearsay.
It's a good objection with that too. I do appreciate that, but I'm gonna allow it. You may proceed.
So, Ms. Renard, just to clarify what we were talking about just a moment ago, you were told to investigate this case because your CEO believed that Ms. Basha had killed Lou Donaldson, right?
Yes, that was one of the reasons.
And the other reason was that your CEO believed that Ms. Basha had forged that will, right?
Yes.
Now, you've been a forensic document examiner for 23 years.
I believe so.
And during that time, you've reviewed a lot of wills.
That's correct.
Hundreds even?
Yeah, I'd put that in that ballpark.
And that's part of what you do as your job for Summit Life Insurance, right?
It is.
And you'd agree with me that in doing this job, you make reports.
Yes.
And it's important to you that your reports are accurate.
That's correct.
It's important to you that they represent your true opinion as to your investigation.
Yes, that is correct.
I'm showing you on the screen what's been pre-admitted as Lou Donaldson's alleged last will and testament. Your conclusion was that this will wasn't forged, isn't that right?
Yes, that was my conclusion.
I want you to read along with me silently while I read out from the second paragraph here. If I should die or disappear, I give to Karen Basha absolutely all of my real and personal property. I read that correctly, didn't I?
Yes.
And you'd agree with me that this die or disappear language is unusual.
Yes, it is unusual to see specifically the disappear word in a will.
And in your 23 years of experience, in fact, you've never seen this language used in any other will.
That is correct.
And you've never seen it used in the hundreds of wills that you've reviewed.
This is the first time, yes.
But that's what's in the will that the defendant came up with, right?
I'm sorry?
That's what's in this will that the defendants came up with, correct?
It's in the will that I believe Mr. Donaldson came up with.
And this is the same will that Miss Basha submitted to probate, right?
It is the will she submitted, yes.
I want to take a look at the bottom half of this document here. You discussed on direct examination how you investigated into the two witnesses here. Now, you'd agree with me that a beneficiary is the person who benefits from a will, right?
Yes.
And the beneficiary of Lou Donaldson's will, that was Karen Basha.
That is correct.
And not only was the defendant the beneficiary of this will, she was also a witness.
That is correct.
So one of the two people that is testifying that this will is valid is the same person that got $5 million from it. Isn't that right?
Yes, that is correct.
And in fact, the defendant is the only person out of the three that were allegedly present for this will that hasn't disappeared yet, right?
To my knowledge, yes.
Well, let's talk about the other witnesses. The other witness that you contacted on this will was Samantha Lane.
That is correct.
And without going into the conversations that you had with Miss Lane, you did speak to her, right?
Yes.
And after you spoke with her the first time, you weren't able to successfully contact her after that.
No, I have not been able to reach her since our first conversation.
And you've made sufficient attempts to try to reach out to her.
I believe I've tried to contact her.
And after you spoke to her on the phone that first time, you received a letter in the mail.
I do believe I did.
And that letter that you received in the mail had the signature Samantha Lane on it.
It did.
And that letter stated that Samantha Lane was coerced into signing this will, right?
It did.
And that letter stated that Samantha Lane didn't see Lou Donaldson sign this will. Isn't that right?
Objection, Your Honor, to hearsay.
Counsel, your response to hearsay.
Yes, Your Honor. Under 703, this witness is allowed to rely on hearsay in making her ultimate conclusion. Additionally, Your Honor, we've already testified as to some of these statements. This is actually the third statement from this letter that this witness has testified to, and she's allowed to do so as she's an expert witness and use this letter in drawing her ultimate conclusion in this case as to whether or not Lou Donaldson's will was forged.
Your response, counsel?
Your Honor, under 703, for an otherwise inadmissible piece of evidence to become admissible, it must be substantially more probative than it is prejudicial for the jury to hear it. Now, opposing counsel has not been able to elicit that Chris Renard was able to follow up with Samantha Lane. They have not been able to elicit that Chris Renard was able to verify that that letter was authentic. They have not been able to verify even that Chris Renard believed in the contents of that letter. And to that end, it does not meet that high bar set by 703 of substantially more probative than it is prejudicial. It is incredibly prejudicial for the jury to hear this testimony about a letter of dubious authenticity at best that this expert has not even testified to believing to be true.
Any response, counsel?
Yes, Your Honor, we're not admitting this exhibit into evidence, and we're not required to make those findings here. Your Honor, we're asking this witness to testify as an expert as to hearsay that she relied on in making her conclusion. Your Honor, what this testimony is from a letter. And regardless of whether or not Ms. Renard believed it to be true, that letter has extreme probative value in this case, and of course it's prejudicial to the defendant. Your Honor, what this letter states is exactly what Ms. Renard said, that one of the witnesses to Lou Donaldson's will was coerced and threatened into signing it, which, as we've heard throughout this case, that's a habit of the defendant and goes exactly to one of our elements in this claim, that Karen Basha did in fact kill Lou Donaldson and threatened him just like she did the other two people that have disappeared.
All right. I don't necessarily, it's cross-examination. So, but I don't necessarily believe that there's quite enough foundation in order to get into a number of these statements, but I understand you want to ask about them. It's going to be a bit of a walking a tightrope, because I don't believe that the letter should come in. And I understand that you're not offering to put the letter into, to enter it as an exhibit. But I will overrule the objection. We'll see where this necessarily goes. The council has put forth that they're not going to enter the particular letter. So the objection's overruled, and I'd like the council to understand that you are on a very, you've just got a very tiny little bit of leeway for this.
Your Honor, may I reserve the right to re-raise this objection pending redirect?
You may.
Mr. Nard, Mr. Nard, we were talking a moment ago about a letter that you received during your investigation with Lou Donaldson, a letter that you mentioned was signed with the name Samantha Lane, right?
Sorry, I was muted. Yes, that signature was on the bottom of the document.
And that document stated that the signer didn't see Lou Donaldson sign that will.
Yes, whoever sent that letter wrote that.
Now, just to clarify what we had mentioned a moment ago, you haven't been able to get into touch with Samantha Lane since you received this note.
That's correct.
You don't know where she is.
No.
It's as if she just disappeared, right?
I don't know if I'd put it in those words, but I have not been able to personally contact her.
Just like Lou Donaldson?
I don't understand what you mean.
Let's move on to a different part of this will. I want to talk to you about the signature of Lou Donaldson. On direct examination, you testified that it's your belief that this will as a whole is not a forgery, including the signature, right?
That is correct. Yes, that is correct.
You made a signature comparison chart in this case, didn't you?
I did.
Your Honor, permission to publish on the screen Ms. Renard's signature comparison chart that she made during her investigation.
Hold on one second. Has that been entered into evidence?
It has not, Your Honor, and we weren't intending to, but if Your Honor would like us to, we'd be happy to comply.
Yeah, we're not going to show that to the jury unless it's been entered.
Ms. Renard, you made a signature comparison chart for this case, correct?
I did.
Would you mind pulling up that signature comparison chart on your screen?
Yes.
Do you have it pulled up?
I do.
And this is the signature comparison chart that you made.
It is.
And there haven't been any changes made to this document or to the signatures pictured.
No, there have not.
And in the bottom left-hand corner of that document is your signature, right?
Yes.
And this is a true and correct copy of the signature comparison chart that you made for your investigation into Lou Donaldson's disappearance.
It is.
Your Honor, at this time, plaintiff offers what has been identified as Chris Renard's signature comparison chart into evidence.
Any objection?
No objection, Your Honor.
All right, it'll be entered, and it's going to be exhibit, I believe, I've lost track of my exhibits, 5?
Yes, Your Honor, it'd be plaintiff exhibit 5. May we also publish it to the jury at this time?
You may.
I want to take a look here down at the bottom of this document at your notes section. These are the notes that you made for your investigation, right?
Yes.
And in these notes, you wrote that it's possible that someone tried to copy Mr. Donaldson's signature, correct?
Yes.
And in fact, you also wrote that your finding as to the signature on Lou Donaldson's will was inconclusive.
Yes, I did say that I could not decide whether, or I could not conclude whether it was genuine or non-genuine.
And inconclusive would not be consistent with the greater weight of evidence, would it?
I'm sorry, could you repeat the question? My computer cut out.
Inconclusive would not be consistent with the greater weight of the evidence, would it?
I don't know what you mean by that question.
That's all right, Mr. Nard, we'll move on. So your testimony here today is that this will is not a forgery, despite the fact that you couldn't come to a conclusion about whether or not the signature on the will is genuine. Did I get that correct?
Yes, I believed that this will was not a forgery, despite that assertion.
Despite the assertion that you couldn't determine Lou Donaldson's signature was genuine, right?
Or not genuine.
I don't have any further questions about the signature comparison chart. I do have a few questions about your investigation generally. You testified on direct examination that It's your belief from the sheriff's department that the defendant had an alibi, right?
Yes.
But you weren't there for the sheriff's department investigation.
No, I was not.
You didn't go visit the tiger sanctuary at the time of Lou Donaldson's disappearance.
No, I did not.
In fact, you didn't investigate this case until 5 years after Lou Donaldson disappeared.
It was at that point that we had the ability to consider making that payout for that life insurance policy. So no, at that point, before that point, I could not have done the investigation.
And the reality is, Ms. Renard, that you're paid to make sure that only valid claims are paid out by Summit Life Insurance.
That is correct.
And you were here today to explain your allowance of a $5 million payout to the defendant.
Yes.
And you've testified, I believe you said on direct, about 24 times for Summit Life Insurance.
I have, yes.
If the jury here today finds that you wrongfully had money paid out to the defendant, that would impact your credibility in the future, wouldn't it?
It could impact the credibility, but I don't believe that that's an issue right now.
Pass the witness.
Redirect.
Yes, Your Honor, briefly, court's indulgence to construct the well.
Certainly.
Ms. Renard, I just want to cover some of the things that Ms. Cox asked you about on cross-examination. She started off asking you about that signature being genuine or not genuine. Did that signature appear genuine to you?
It did.
Ms. Renard Ms. Cox also asked you a lot about a letter you received from Samantha Lane. Ms. Renard, do you remember receiving this letter?
I do.
What did you think of this letter?
I thought it was very strange, and I did not believe it to be a true letter.
Were you able to contact Ms. Lane about this letter?
No, unfortunately not.
Did receiving this letter change your conclusion in any way?
No, it did not.
Did you rely on this letter when you were coming to your conclusions that you testified about today?
No, I did not.
No further questions, Your Honor. At this time, the defense would re-raise its objection to hearsay as to the contents of that letter. Ms. Renard just testified that she did not rely on the contents of that letter in coming to her conclusion, putting it firmly out of the bounds of 703. In fact, she testified she thought it was a hoax.
Counsel, your response to that?
Yes, Your Honor. Regardless of whether or not Ms. Renard relied on it in drawing her ultimate conclusion, it was a part of her investigation and a part of the evidence that she looked at to determine her conclusion in this case. She did rely on it on the fact that she looked at it to determine whether or not it would impact her conclusion. It does still fall under the realm of 703 because it is data, a letter, an investigation that she was looking to as to the witnesses of Lou Donaldson's will to determine if the will was forged. Regardless of how she weighed it, it was a piece of evidence that was taken into consideration to make her conclusion in this case and is still allowed under 703.
Counsel, I understand why you've raised the objection. I'm going to overrule that. You can certainly address any of these issues in a closing argument.
Yes, Your Honor. With that, the defense has nothing further and is ready to move into closings after a brief recess.
Certainly. Let's go ahead and take just a couple of minutes to get a time check and the rest of it. Let's get started. And I warn you, I like to start early. We'll say at 8:55, we'll proceed to closing statements. That way the counsel and everyone, if there's a quick break, 8:55. Court's in recess. Okay, it's 8:55 and it looks like the parties are back. And I see that in the chat, for the record, that we have been, there's been a bit of discussion and information about the remaining time that is there. It looks like plaintiffs have used 51 minutes. It's 70 minutes total, so that leaves 19 minutes. And then there's also the 41 minutes for the defense, leaving goodness, basically 29 minutes for a closing. That is your time. I hopefully won't necessarily use all of it, but it is your time. And looks like we've also coordinated on the giving the warnings. Is it correct then that the witness may be able to just cut in and give that warning out loud? Is that correct?
Yes, Your Honor.
All right. And I don't believe defense will necessarily need a warning, but if you'd like a warning, that's fine too.
No warning will be necessary, Your Honor.
Okay, great. Then let's, again, per my pretrial ruling, I'm going to go ahead and close off the camera, and objections can still be raised during the closing argument, but let's give this entire screen to each individual advocate. Is there anything else that needs to be brought up at this time?
Nothing from the plaintiff, Your Honor.
All right. Then we'll go ahead and proceed to closing argument.
At this time, may we reserve 3 minutes for rebuttal?
Yes, 3 minutes reserved.
May it please the court, counsel, members of the jury, you heard that Lou Donaldson said, if anything ever happened to me, be sure to have the police look into Karen, because she'll be the one responsible for my death. Members of the jury, we told you this isn't a case of coincidences. And now that you've heard and seen the evidence, you know that's true. It all started on June 12th, 2012. Lou Donaldson had had enough. He told the court he wanted out of his marriage, that she threatened to kill him, and that he didn't feel safe. And then just 2 days later, the defendant would have you believe he signed everything over to her, his last will and testament, cutting out the daughter who he loved, the daughter who worked alongside him for years. And then a week later, the defendant found the van and the glasses that Lou Donaldson needed to be able to fly, to be able to see. They were just left behind. And there's one thing she did forget, and that happened back on August 19th, 2012. You see, Karen realized that Lou Donaldson wouldn't just leave his daughter out of his will. Lou Donaldson loved his daughter, Cam. He would make sure that she's okay, that she was protected. So he left her a part of his will in a lockbox in her desk. Now, Ms. Baja knew she had to make sure to get her claws on that will before she fired Cam, because what do you do as soon as you get fired? You clean out your desk. And she knew that Cam Donaldson would take that will. She'd leave with it. And then all of her plans to cash in on the fortune, her plans to get wild life, go out the door. So Miss Baja went to the office early that morning. She took that will. And 5 years later, Miss Baja had her husband declared legally dead. Now, I want to make sure the dates are clear here. She had to wait 5 years to have him declared legally dead. He went missing on August 17, 2012. She petitioned the court on August 18, 2017, 5 years to the day. 5 years to the day. She made sure she could get her claws on his fortune. She probated the will. She cashed in on the life insurance. She cashed in on Lou. Members of the jury, I'm showing you instruction form 13 on your screen here. As the plaintiffs in this case, we had to prove to you these 4 elements by the preponderance of the elements. We had the burden, and now you've seen it and heard the testimony, you know we've met it. Starting with first one, Lou Donaldson is dead. Taylor Pride got on the stand, and Taylor Pride told you that the defendant had Lou Donaldson declared legally dead on August 18th, 2017. Taylor Pride told you that Lou Donaldson hasn't been seen since August 17th, 2012, and that there is no trace of him anywhere. In fact, every witness has gotten on the stand and said, well, they can't find Lou Donaldson. Second thing we have to prove to you is the death of Lou Donaldson was caused by the defendant's intentional or reckless conduct. I want to take you back to when Exotic Bob was testifying. He's an interesting man, Mr. Bob, and he said that Karen Baja looked at him and said, if you double cross me on this deal, I will do to you exactly as I did to my husband, and I won't make up. Costa Rica this time. She threatened him. She threatened Exotic Bob, told him how she killed her own husband. You heard Taylor Pride testify as well that he looked into these claims that Lou Donaldson just got on a plane and disappear. He found no evidence of that. He sent a guy down to Costa Rica and they couldn't find anything. He looked at his bank statements and there was activity in the statements. Activity leading up to the last day Lou Donaldson was seen. And then after that, nothing. You even heard the defendant testify. And it was interesting. She said that it was normal for Lou Donaldson to just disappear. He would just take off. She said 2 different things. One thing she said is he was a secretive man. He would just leave. But if you remember, the second thing she said he would always leave instructions. You heard from Cam Donaldson. Cam told you that the defendant said, I'll kill you, to her father. You heard her talk about the marital troubles and the issues. You even heard a little bit from the defendant about this alleged mistress. But even though there was another woman in the marriage, they were doing okay. He would file a temporary restraining order saying he wanted out and that he didn't feel safe. But then they worked through it in 2 days and he would just leave her everything. You heard from Miss Baja. She talked about how the mistress made things difficult for them. The third thing we had to prove to you was the plaintiff, Cam Donaldson, suffered injuries, damages, or losses as the result of the death of Lou Donaldson. Cam Donaldson talked to you about how much she loved her father, loves her father, about how she just wants to continue on his legacy. She told you about working with him, about going to dinner with him on Sunday nights. Now she'll never have that last meal. She'll never have another phone call or get another text from her dad. The defendant's conduct, either intentionally or recklessly, was the cause of the plaintiff's injuries and damages.
Ms. Wayne, that's 8 minutes.
Thank you. Ladies and gentlemen of the jury, Miss Baja had obvious motive to make sure Lou Donaldson's fortune didn't slip away like he was. She told you he was getting out of the marriage. He wanted out, was her own words. So she had to act fast, and she did. She acted in 2 days to get that will forged, and then just several weeks until he disappeared. Members of the jury, you're going to be asked to do something very difficult. You're going to be asked, how much did losing a father cost Cam? Now, we're not asking you to put a monetary value on Mr. Donaldson's life. What we are asking you to do is understand that we can't bring Lou Donaldson back from the dead. We wish we could. Cam wishes we could, but we can't give her her father. We can't give her what she wants. But what the law will allow is it will allow us to give her some type of monetary means. Miss Donaldson is only asking for $10.5 million. That's the same amount Miss Baja got for declaring Mr. Donaldson dead. It's a reasonable amount. It's the amount that will allow her to carry on her father's legacy. Just imagine her waiting for her dad to walk through those doors, waiting for her dad to call her. And that's why she wasn't over for dinner. Now Miss Donaldson has to wake up every morning wondering what happened to her dad and why the defendant would do this to her family. Miss Donaldson's been let down twice now. She's been let down by the Summit Life Insurance Company who paid out the policy. And she's been let down by the sheriff's department, the department where the defendant's brother works for, because the case is still ongoing. Members of the jury, you're Miss Donaldson's last hope to hold the person responsible for her father's death accountable. That's why we ask you to return jury verdict form A. I'm going to have a chance to speak with you after opposing counsel, but I want you to think, while they're talking, why would a man who loved his daughter, loved her so much, cut her out his entire will just 2 days after saying he wanted out of his marriage?
Closing from the defense.
Yes, Your Honor, a moment to swap my feed.
Certainly.
This case isn't about coincidences. Like opposing counsel told you, Lou Donaldson had enough. He wanted out. So he left. Not a coincidence, but Lou Donaldson's choice. Off the books, off the grid, and off the hook. That's what this case comes down to. Lou Donaldson lived his life off the books, secretively sneaking off to Costa Rica with somebody as close to him as his daughter, none the wiser. He dropped off the grid. Intentionally or accidentally, Lou Donaldson left and never came back to his wife. But before his final disappearing act, and this is key, Lou Donaldson wanted to be off the hook. So to feel less guilty for abandoning her, 2 days before he disappeared, he made sure that Miss Baja was taken care of in his will. The plaintiff's case is a paper tiger, a scary sounding scheme without substance, contrived by an angry and hurt daughter who was unable to accept her father's decisions. Members of the jury, at the end of the day, Lou Donaldson's disappearance is just that, a disappearance. Nobody knows, and based on how he lived his life, nobody could know where he really disappeared to. As my co-counsel Karna Kajar told you at the beginning of trial, my name is Robert Fairbanks, and I have the privilege of representing the defendant in this case, Ms. Karen Baja. Now, before we talk more about how Lou Donaldson lived his life off the books, off the grid, and ultimately wanted to be off the hook, I want to talk to you about the burden of proof. Because the plaintiff, Cam Donaldson, brought this case, she carries all the burden of proof. Ms. Baja doesn't have a burden. She doesn't have to prove anything. Now, that's critical to remember. The plaintiff carries all the burden for every single element. She is required to prove it to you, the jury, by a preponderance of evidence. So to prevail, she must somehow convince you that each and every element of her claim is more likely true than not true. So that means that at the end of all this, if you feel like there just isn't enough evidence one way or the other, if you feel like it's a coin flip, a 50-50 chance on any single element, then plaintiff has failed to meet her burden. And when we look at the actual evidence, you'll see that the plaintiff falls far short of meeting her burden for the two most critical elements of her claim. The plaintiff brought her claim under the Statesville Wrongful Death Act. So to carry her burden, plaintiff had to prove four things to you. 1, Lou Donaldson is dead. 2, his death was intentionally or recklessly caused by Ms. Baja's conduct. 3, the plaintiff suffered injuries, damages, or losses as a result of Lou Donaldson's death. And 4, the plaintiff's injuries and damages were caused by Ms. Baja's conduct. Now, I'm going to focus on the first two elements because the plaintiff's inability to establish those two renders the rest irrelevant. I'm then going to briefly touch on that last element, which sheds a little light on why the plaintiff brought this claim in the first case. So the two key elements the plaintiff failed to prove to you are 1, Lou Donaldson is in fact dead, and 2, if Lou Donaldson died, his death was caused by Ms. Baja's intentional or reckless conduct. And when we look at the first element, I want you to focus on Lou Donaldson's off-the-book lifestyle and ask, how likely is it that Lou Donaldson is even dead? How can we know? After everything you've heard and seen today, what do we actually know about Lou Donaldson? What did Lou Donaldson do to live life off the books? The plaintiff claimed she knew everything about her dad's business. She told you that she scheduled all of his meetings. She wrote the checks. She answered the phones. She ordered the supplies. She ran the books. Lou Donaldson was totally off the books, content to operate in the background and let his daughter handle the public side of his business for him. And despite doing the books for Lou Donaldson, there were still things that her dad kept completely off the books, secret from even her. The plaintiff admitted to you that there was a lot Lou Donaldson kept secret. Nobody knew how many planes he had. He frequently bought and sold planes, but never properly registered them. He didn't have a valid pilot's license. Her father would fly without logging a flight plan. Think about that. Somebody would fly without a valid license and without logging a flight plan. That's about as off the book as you can get. And Ms. Baja corroborated what the plaintiff told you. She agreed that Lou Donaldson was a private and secretive man. Based on his off-the-book lifestyle, Lou Donaldson could be alive and well without anybody involved in this case being remotely aware. Now, the plaintiff has emphasized some bank records, about $100,000, which she says is proof Lou Donaldson must be dead because otherwise, why haven't there been any withdrawals? Well, the plaintiff is trying to keep you from using your common sense. Lou Donaldson's estate was valued in the millions of dollars. If he was trying to disappear to start a new life with his mistress, it would actually be surprising if he had withdrawn that money. Think about everything Lou Donaldson kept off the books. Would it be surprising if he kept some accounts off the books? Some untraceable funds? The plaintiff on the stand today told you, she emphasized she only handled the business records. What about her father's personal records? Instead of thinking Lou Donaldson is dead because he hasn't touched a relatively small business account, it's far more likely Lou Donaldson is off living with accounts off the books nobody but him knew about. And the glasses. Again, the plaintiff is asking you to ignore your common sense. Nobody could keep track of how many airplanes Lou Donaldson had. Airplanes. Does the plaintiff really expect you to believe he didn't have an extra pair of glasses somewhere that plaintiff was unaware of? And lastly, Lou Donaldson's legal status. Plaintiff claims the fact he was legally declared dead means he is actually dead. That's just not necessarily true. Karen Baja needed closure. And after 5 years, it was clear that her Prince Charming was never coming back. So she did what she could to try and get that closure and make sure she and her cats would be taken care of. But declaring somebody legally dead doesn't kill them. At the end of the day, because of how off the book Lou Donaldson lived his life, all we really know, all anybody knows, is that he dropped off the grid. Past that, it's pure speculation. So, members of the jury, the case stops here. Because the plaintiff failed to prove the very first element, you have all the information you need to render a verdict in favor of Miss Baja. But for the sake of being complete, I'm going to continue by talking about how Lou Donaldson dropped off the grid and why he wanted to be off the hook. So what did Lou Donaldson do to drop off the grid? Well, to talk more about when Lou Donaldson dropped off the grid, let's turn to the second element, whether Miss Baja intentionally or recklessly caused Lou Donaldson's death. Even if you think Lou Donaldson is dead, the reasons and the way he dropped off the grid show that Miss Baja just didn't have anything to do with any of it. So let's start with the reasons Lou Donaldson dropped off the grid. You heard there were family tensions. His privacy was testing the strength of his marriage to Miss Baja. He was taking secret and sudden trips to visit his international mistress in Costa Rica. There was talk of a divorce, a restraining order. Lou Donaldson wanted out. And he knew that his off-the-book lifestyle would make it easy to just drop off the grid and vanish. And let's talk about the way he dropped off the grid. Let's turn to the night he disappeared. From the outset, we don't know what he was doing. He left the office. He said goodnight to his daughter. And that's it. Miss Baja explained to you that she often didn't know what he was doing. For all she knew that night, he was already on his way to Costa Rica, eager to get to his international mistress. She had to run an errand, had some car trouble. Nothing sketchy there. Her brother, who she knew was working that night, picked her up. It was 3 a.m. Even if she had known where her husband was, why would she have called somebody who was probably sleeping when she knew her brother was awake and in the area? And past that, even the plaintiff doesn't have anything to add because nobody, and I mean nobody, actually knows what Lou Donaldson was up to. All we know is that he was not with Miss Baja that night. Lou Donaldson dropped off the grid and we have no idea what else happened. So if Lou Donaldson died that night, it was during his attempt to drop off the grid. You heard from the insurance company's investigator, Chris Renard, the most objective person in this entire case, who determined Miss Baja had nothing to do with Lou Donaldson's possible death. If Lou Donaldson dies, nobody knows how. Maybe it was when he was rushing to visit his mistress. So that's why if Lou Donaldson is actually dead, which plaintiff has not proven, there is no evidence connected to Miss Baja. There's no body, no evidence of foul play, no murder weapon, no theory of what happened to Lou Donaldson, no theory of how he died, no theory of where the body might be, no theory of anything. The plaintiff gave you nothing. No evidence to suggest Miss Baja had anything to do with Lou Donaldson's potential death. Now, the plaintiff did play you a video of Exotic Bob. Well, members of the jury, you have access to that recording while you deliberate today. Play the first 30 seconds, listen to it, look at it. Exotic Bob himself tells you everything you need to know. He tells you his motive for making up all those ridiculous allegations he was singing about. You heard. He thinks he is in prison because of Miss Baja, and he is using this litigation as an opportunity to try and get even. He wants revenge. Because the plaintiff doesn't have any substantive evidence, they're grasping at straws. They're putting people like Exotic Bob in front of you and hoping they can convince you of something that just didn't happen. Now, I want to briefly touch on the last element of this case. Since the plaintiff did not prove that Lou Donaldson died or that Miss Baja caused his death, it's not critical to the case, but I think it sheds some light on why all this is happening. So to understand why Miss Baja didn't cause the plaintiff's pain, regardless of whether Lou Donaldson is alive or dead, we need to talk about Lou Donaldson and his desire to be off the hook from all the responsibility in his life before he dropped off the grid. He wanted to disappear, drop off the grid, and start a new life. But he felt guilty. He wanted to be off the hook for taking care of his wife and off the hook for taking care of his business. And what did Lou Donaldson do to get off the hook? Not a coincidence. A couple days after a very stressful moment, after he already decided he was leaving to live with his mistress in Costa Rica, what did he do? What did he decide to do to get off the hook? He changed his will to make sure Miss Baja would be taken care of. Because members of the jury, despite the issues in his marriage, despite the secrets, despite the mistress, he still cared for his wife. He remembered that he was her Prince Charming. He did not want to be, he couldn't be responsible. He didn't want to be on the hook for her losing her lifestyle, her cats, and everything she cared about so much. So he changed the will to make sure he was off the hook, to make sure no matter what, Miss Baja would be taken care of. That is what Lou Donaldson wanted, and that's what happened here. Now, the plaintiff's hired expert tried to raise some doubts about the authenticity of the will. You were told that if the signature looks different than the samples, it might be a forgery. He also said, if it looks the same, it also might be a forgery. There's this range, this broad range. Well, it sounded like pretty much anywhere in the range, it's going to be a forgery. It sounds like the plaintiff brought you an expert who was just looking for a forgery no matter what. And remember, the third-party expert from the insurance company, Ms. Renard, concluded the will was legitimate and the insurance policy should pay out to Ms. Baja. And the plaintiff brought up some letter, a letter that the insurance company expert thought was fake, didn't think was credible, couldn't authenticate. And we all know insurance companies look for ways out of paying. If Ms. Renard thought there was something there, she would have looked into it. But she didn't think there was something there. End of story. Lou Donaldson's choice to be off the hook made the plaintiff feel abandoned and angry. And I think we can all understand that. Cam Donaldson did a lot for her father. She cared for him. We all got to see how hurt Cam felt when she wasn't included in her father's will. The plaintiff feels like she deserves something for the work she did on Lou Donaldson's behalf. And she's probably right. But her dad just didn't feel that way. And the plaintiff, now unable to accept her father's choices, hurt and angry, is directing that hurt and anger at Miss Baja. And the plaintiff admitted she hates Miss Baja. She said she wishes she would be attacked and eaten by one of her tigers. That's strong. And that resentment didn't come about because of her father's disappearance. Opposing counsel early in today's trial repeated to you a phrase, now or never. Well, if a daughter thinks her father has been murdered, finding the truth is a now or never moment. Speed is essential. But the plaintiff waited 5 years to finally hire an investigator to look into her father's disappearance. Why didn't she hire one right away if she was so convinced that this was Miss Baja's doing? Why did she wait 5 long years? It's because it ultimately wasn't about Miss Baja or her father's disappearance. It's because of the money. She hired an investigator when the insurance company was going to pay out. This whole case goes back to the plaintiff's jealousy and anger and frustration at her father's decisions. It's been there, festering and growing, consuming her since Miss Baja entered her father's life. And she felt that first pang of jealousy, that realization that somebody else might get her father's love, attention, and money that she covets so much. That's probably why Lou Donaldson never told his daughter about his mistress. He didn't want to give her another target for that hateful jealousy. So that's the lens we need to look at this entire case through, the motivating force behind plaintiff's wild allegations. Any damages or injuries suffered by plaintiff were not caused by Miss Baja. They weren't caused by coincidences. They were caused by her father's intentional choices, his choice to travel, change the will, and his desire to disappear and be off the hook. So, to sum things up, the plaintiff had to somehow prove to you that it was more likely true than not that Lou Donaldson is dead. And even if she could do that, she also had to prove to you that it was more likely than not that Miss Baja intentionally or recklessly caused his death. Plaintiff didn't prove anything because she couldn't prove anything. The evidence just isn't there, no matter how angry and jealous, maybe rightfully so, she is. There is no murder weapon. There is no body. There is no credible theory as to how Miss Baja would have even killed him. Members of the jury, you are here today to decide if my client is responsible for Lou Donaldson's death, and the plaintiff couldn't even prove to you that Lou Donaldson is dead. Off the books, off the grid, off the hook. After all the testimony, all the evidence, the plaintiff's case creates far more questions than it answers. So I ask you, apply your common sense to what we do know and think about what this case comes down to. Lou Donaldson intentionally lived his life off the book. He dropped off the grid and nobody knows what happened to him. Probably never will. And before he dropped off the grid, he wanted to be off the hook. He wanted to make sure Miss Baja and his business would be taken care of. So he changed his will to reflect that. We cannot hold Miss Baja responsible for Lou Donaldson's choices, and no amount of misplaced anger from the plaintiff should change that. The plaintiff's pain is understandable, but it isn't Miss Baja's fault. Find Miss Baja not liable.
From the plaintiff, rebuttal.
May it please the court, off the grid, off the books, off the hook. The only person that wants off the hook here is Karen Baja. Counsel just said, talk about Lou Donald's choices. Let's talk about Lou Donaldson's choices here today. He made one choice. He chose to file a temporary restraining order. He told the court that the defendant was going to kill him, and it was denied. He was afraid for his life. That was his choice, to file a temporary restraining order. It was not his choice to cut his daughter out of his will. It was not his choice to die. It was not his choice for her to steal his one known will and testament. And it was not his choice to leave behind the glasses he always has to wear to be able to go anywhere. And it was not his choice to be declared legally dead 5 years later. Lou Donaldson had no choices in this case. Nothing Lou Donaldson wanted happened, but everything that the defendant wanted happened. It was her now or never moment. Plaintiff's counsel made an interesting comment, or defense counsel made an interesting comment saying that Cam Donaldson was jealous of the love and the tension and the money. But there's been no cover up. Lou Donaldson wanted out of his marriage because he had a mistress in Costa Rica. That has been the defense's claim this whole time. So if there is one person who wanted the love, the attention, and the money, it was the wife he was going to leave behind. It was the wife he was afraid of. It was the wife who he was not going to leave a cent to or any of the cats that she loved. Lou Donaldson didn't have a choice. Members of the jury, you were told a lot to use your common sense. I trust that you look at this case and see this is not just a whole bunch of coincidences. You should return jury verdict form A and hold Ms. Basha responsible for the choice she made.
And that concludes our trial. We definitely give some applause to the advocates and witnesses. Wow. We're going to do comments because for the scoring jurors, just as a reminder, you'll end up going to the Basecamp link, go to scoring, fill in your information on that score. When you click on scoring, you'll fill in your identifying information and then do the scores and feedback there. I will do the same thing. I just have to say, wow, you were all constantly throughout the trial. I was thinking, that's really good. That's a good point. Obviously, there are little things here and there, but be very proud of yourselves. You put in a ton of work and it shows. So best of luck in the rest of the tournament. Get some rest and take care. I'm going to go ahead and log it off.
Thank you. Good job.